Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dahil hindi Anglican po, he's very much.
Is that correct?
Literally not true. Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, welcome. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Happy Friday to you. It feels weird to say that because we didn't do the hump day. We never did hump day this week. And it feels weird to say happy Friday. But it is Friday. It's Friday all day long. Hope you first of all, I hope you joined us for the podcast. It was a great one last night. We had a lot of fun. And you know, it just might keep you out of jail. I'm serious. If you missed it, you might end up in jail. That sounds like a dire threat, but watch it and you'll see why. So oh man, it's good. My mics are weird today. Why is it so loud? And then like it's clipping. Let's see. Levels. Test 1, 2. We'll take it down just one notch or so. No, that's a little better. I don't have the clipping. Good morning. I don't know who was first in chat. Was it Emily? Emily, was it you? You have to own up. When I ask, you have to. That's one of the rules. You have to say if it was you, and you have to tell the truth. Let's see. It was Regina. No. Oh, here it goes. Boom. There it is. I love taking ownership, Regina. That is awesome. That is something we wish everyone would emulate to help inspire people to be like Regina Crawford and just own up when they do something wrong. We're going to punish Regina in front of everybody as a lesson to you all. That's right, Regina. We're going to punish you with internet ownership. You were first in chat. Congratulations. and love that you're here first. Somebody has to break the ice, right? When it's all quiet and everyone you go into a new live stream and nobody's talking. You're like, is anybody here? And nobody wants to be that person, right? Well, Regina, today it was you. Thank you. Because once you did that, everyone else can talk freely. We love it, Regina. Congratulations. This goes on your permanent record. Make sure you go over to our YouTube shopping tab and scroll around until you can find the internet ownership certificate. You can help yourself to a copy of one for the low fee of just 50 cents. You can download your own internet ownership form commemorating this occasion. It is suitable for framing, hanging up on the wall, or use as a cover sheet for your CV. You're going to do great with the internet today. Congratulations, Regina. Appreciate that. All right. Regina's like, I break the internet. I've got faith in you. I think you can do this. My mic is just hot today. What did I do last night? Okay, test 1, 2, test 1, 2, check 1, 2. That's not the right one. Okay, test 1, 2, test 1. Oh, there it goes. That was me. I may have bumped the input, so it was a little hot. There we go. Down. Hey. Who said that? Who said that? Mr. Pancake, I saw that. All right. Good morning. Good Friday morning. We have a court hearing to watch today. It happened yesterday. I wanted to wait a bit because the trial has not begun yet. This is a pretrial hearing. But it gives us something to do on Friday to watch. We can also do a little bit of court hopping if so desired, and if there's a case that happens to come up. I know there are a few things.
You look good.
Right, Judge Fleischer. Subtle reminder there. That there are other things to do as well before we start. I knew I was forgetting something. I knew I was forgetting something. The sound is awful. I know. We're going to do what we can on this one. Good evening from Perth, Australia. Hello from to the future, Perth. You guys ahead of us. If the world ends tomorrow, you guys will know first. So do let us know. Let's see. I was going to type that about Fleischer. Yes, he was reminding. I wonder if we have any birthdays. Do we have any birthdays today to sing to? I think we have a couple. Emily, let's see. Good morning, friends. If anyone could send love and well wishes, my mental health is really struggling today. Oh my goodness. Oh. Less than an hour from NOLA. My understanding of NOLA is that's how you guys refer to New Orleans. Is that right? Is NOLA and New Orleans just the same? Or is that going to be North LA? Man. Emily, we'll be thinking of you. Hopefully you got your stickers. Did your sticker arrive yet? You should have a sticker by now in the mail. People. Just because it's 2025 doesn't mean we need to burn everything down. Crazy. All right. Let's sing happy birthday as well. Emily, I love to see it. You got your sticker. That's wonderful. All right, let's sing happy birthday. That always cheers us up, and it also cheers up the people who we sing to because, it's their birthday. So we're going to sing to Jeff, Cyberwriter, Kirsty Ann. Oh, just those three. I always want to add a fourth person because it makes it nice and balanced. And I think that's it. There was something else I wanted to say, and it escaped. It'll come back later. Add Coco to the list. Okay, we'll add Coco as well. Okay, so here we go. It's going to be Jeff, Cyberwriter, Kirsty Ann, and Coco. So everyone, stand up, shoulders back, deep breath, project your voice to the back of the room. Warm up with me, if you will. La 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 la. There we go. Excellent, Jennifer. Appreciate that. Happy birthday to you. Happy birthday to you. Happy birthday, Jeff, Cyberwriter, Christiane, Coco, and Coralie. Happy birthday to you. We got Coralie in there as well. Man, it just sounds hot. Me singing is there's too much Mike. There's too much of me. To everyone who's celebrating their birthday today, including Coco and Coralie, who are late ads, thank you. Thank you for letting us sing to you. Appreciate that. Hopefully you can make your day a little bit more specialer. I realize there are a million places you could be and a million people you could be with. You've chosen to be here with us. The privilege and pleasure is ours. Thank you so much. Help yourself to free pancakes at Denny's, IHOP, Village Inn, McDonald's, Tammy Dunlap's house, and Andy's Grill. All establishments which you should find either near or far from you. We want to help you make your day a little better. So, happy birthday to everyone who's celebrating. Let's see. She's at Disney France today for a big day. Red Pen. I've got one at Disney France right now. My oldest. I think he's over there for a wedding on the other side of the family, this in-laws side of the family. But maybe they're on the same ride today. My friend's son's birthday in Sussex, England was yesterday, says Lisa. Happy birthday to him. Ricky says, got my stickers yesterday. Thank you, sir. Good. Happy birthday, everyone. Sloth life, one more day until I can change my name. That's awesome. Here we go. I think we're coming up on a drum solo. Yeah, this is it. Everyone grab your drumsticks, your air drumsticks if you don't have real ones. We're going to do a big drum finish here. Birthday's a week from Monday. Debbie, we're going to sing to you then. Awesome. Happy birthday. What a way to start the day, really.
Send someone with more experience.
Yes, that would be good as well. I'm glad you're getting your stickers. This is good news. I'm glad. I've got a handful more of letters that need to go out. I know a couple of you. I had a few that I thought I had put in the right place, but they're sitting on the mantle, so I'm sorry.
Are we going to address that?
Beezy, I think yours were some of them. So anyway, I'll send our video I made of the birthday song. Wonderful. Yeah, but a bunch of stickers going back out, so we're all good there. Let's see. See mine yesterday. My cat was sniffing the envelope. Not sure why. I'm glad everyone's getting their stickers. That is really exciting. It really makes me happy. As you can see over my shoulder, I'm watching the volcano in Hawaii, which I need somebody to explain things to me, because I don't, or maybe just put like a banana on there for scale. I can't tell if this is like something that's happening in the size of a shoebox in slow motion, or if this is actually hundreds of feet high in the air. Does anybody know? Anyone down in Hawaii? It looks because of the smoke and the time in the air that it's launching, I don't know, 75, 100 feet up. Is that right? Curious minds. I've been watching it for days and I can't figure out. Are the books in the background a new addition or just a new camera angle? New camera angle. They've always been there, as a matter of fact. And funny thing, right up there, that is the Lucky Care Bear. It was a gift to me from my family. Everyone in my family, like my siblings, has a Care Bear that they're supposed to have in their vehicle hanging from their rearview mirror, which is illegal in most states. I'll admit it. It's a crime. Okay, we're all criminals. And I did not have one. And they assigned me the Lucky Care Bear. But I broke the clip, so it can't be in my car anymore. All right. Just sent you a long message in mod chat regarding the thing I watched this morning. Yay. Josh never sleeps, by the way, for those that are curious. He's actually a robot. He's a very smart robot and very good at what he does. Josh saying we have to go here first before we start our hearing, which is a couple hours long, which is interesting because we have something in the hearing that's coming up that you're gonna love. He says we have to go here to see this video. So give me just a second. Where are we at? Let's go. Trying to find the right one here. Hey Josh, I can't tell which video this is. Like, is it the one that's live right now we have to go back to, or is it the one from yesterday morning? We're waiting for Josh just for a second. Live right now. Okay, do we go back to the beginning?
Thank you.
We're going to go back just a little bit here. Let's see. just ended, but it was a funny, quick moment. The last guy that just happened. Okay, so let's see if this is it. This is a possible case we might follow, I think, here in a bit, a retrial. It's a retrial. It came back hung before the holidays. He and his previous attorney had a falling out, and the attorney withdrew. He told
Kirby Joseph's contract. You know, people think football players get paid a lot of money. And you hear this big old contract, right? But a lot of that money is given to you in accomplishments. If you make so many dollars, you do this, and you do that. You get this,
They bonus to send him.
Right. Well, if he didn't went to the Pro Bowl, he'd have got $3.86 million, and since they snubbed him, he didn't get it.
And he led the league in interception.
And he led the league
I
historic
guess it's sports talk.
number.
Yeah.
And the Lions.
Hey.
But they snubbed him. And blew his $3 million.
See?
Almost
I was
four.
the team.
Almost four.
Right. If I was the team.
The bailiffs are talking football.
That would be nice.
Yeah, I can. I say, you know what? We all can agree. You
should have went.
should have went to the Bowl. I'm that line this second. We'll give you $3.8 million.
Wow, that would be really cool.
That's what teams should do.
Yeah. That would inspire so much loyalty.
Exactly. So when it comes time, when we want to sign,
Right. You remember this?
give us the first crack.
Yeah.
Give us the first crack. Because he's going for that bag at some point. And that's when you say, no, that's you.
The bailiffs just talking football.
We're tied with another team. Stay here with us.
It's a little bit of both. Talking money and football.
They have Sarah's name there.
Obviously, they got a bigger.
Daddy on the inside. It's covered Sarah.
Right.
But if we close,
Stay with us.
stay with us.
But you gotta get us the grip.
We take care of our people. That's a great idea.
They can do it.
Okay, we've got to find where the defendant's at. Josh says the football is not the interesting part. Don't think that's it. It might have been right before then. Is this him?
What if I just...
No. Is there any way you could give me the number of minutes back from live it is? Because it's hard for me to find this. Maybe just share the link with the exact timestamp as well as the destination. To this guy?
Porque estar en el medio.
No, that's not him.
D-U-P-R-E-E. Okay.
So that word again,
Oh, at Dupree. Okay.
dash legal.com.
Dupree-legal. Somebody email address.
Trial was a farce and a mockery in the pursuit of justice.
Okay, this is the guy, I think. That's the exact moment. So let's back up just a bit. I found it, Josh. We're good. I think we might be 10 or 15, 30 seconds or so before this happens, but we'll start from here. Yes, we are going to do a hearing from yesterday. The case has not started yet. It's a pretrial hearing, but it's a murder trial. It's a stabby times 60 with a suitcase. But we'll do that hearing first. And I'll do my best to fix the audio because it's not great.
Can you bring out baby?
I guess it would be stabby times 30 instead of so stabby times 60. Stabby times 30.
You can step up to turn for baby.
Thanks.
Mr. Penny, we're going to call Bailey now.
I think Bailey heard that.
Good morning, sir. Good morning, Mr. Penny. Can you hear us?
He's like, yeah, over Zoom and through the walls.
Can you hear us?
Judge, if you're speaking to me, I cannot hear you.
Yep, I am.
That might be on my end. Just one moment, please.
It is.
Okay.
You want to stand on the computer side. Okay.
All right, let's call the case.
Here we go. Sorry, Judge.
Okay. Can you hear me?
I can. Sorry about that.
Okay, no problem. All right, go ahead.
Calling case 2100262901, people of the state of Michigan versus Robert Lee Bailey Jr. This matter is scheduled today for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Matthew Penny, P74079 for the people.
Good morning.
Good morning, Your Honor. Edward Bajoka, P70919 on behalf of Mr. Bailey, who's here to my left.
Okay. And sir, can you spell your name for the record, please?
Yes, Your Honor. Bajoka is Bajoka. Edward, first name, common spell.
Okay, thank you. Sir, can you state your name for the record?
Robert Bailey.
Okay. And you are the new attorney on this matter, is that correct, sir?
Yes, Your Honor. Received an assignment yesterday afternoon for this case.
Okay.
Received an assignment. He's not happy.
So we need to set a trial date on this matter.
Nothing's
Your Honor,
happening
Mr.
in
Penny
April.
and I had a brief conversation this morning, hoping for an April trial date.
April would be great for me.
If the court has something available.
All right. How's April the 7th?
I think that'll work for me, Your Honor.
I'm supposed to be out of town starting on April the 11th, Your Honor. And since this was a 2-weeker, I don't think that's a great idea.
April 14th. Or I'm sorry. You're going to be out of town until when?
Well, starting the 11th and out of town until it's either the 14th or the 15th. Could we do the 21st?
What about March 31st?
I have another murder that's supposed to be 2 weeks, but I don't know if it's actually 2, and I don't want to book this one and have it run in. Do we want to do?
Matthew Penny's
If
got
you're
a lot
okay
of
with the
murders.
Wednesday start, I could start on Wednesday, April the 16th, or we could start Monday the 21st.
All right. How about April 21st?
That's what he
That's
said.
fine by me.
That's good for me as well, Your Honor.
All right, so both attorneys need to get together, work out the final jury instructions, the 3s forward, including the 3s, also a verdict form. I'll do the initial voir dire, and then each of you get up to 30 minutes for voir dire. Any exhibits, if you can have those pre-marked.
Thank you, Your Honor.
Anything else we need to take up?
I'm not sure if the court knows or Mr. Penny knows the status of the transcripts.
I don't.
Okay, I'll figure that out.
Yeah.
Other
You can
than,
make sure those are ordered.
Your Honor, Mr. Bailey did have an objection that he would like to place on the record. I don't have any issue with that.
All right, go ahead, Ms. Bailey.
Sure.
All right. I would like to make an objection on the record. I cannot accept your trial date, nor will I consent to it. I believe double jeopardy is attached to this case. The first trial was a farce and a mockery in the pursuit of justice, and the court no longer has jurisdiction under Michigan Court Rule 6.004. Defendant also made clear in the record that he does not elect to avail himself of any established procedures that violate his Michigan and U.S. constitutional right within his personal jurisdiction, nor am I willing to forfeit or waive any of my fundamental rights.
The lawyer's like, yeah, that's
Your motion is denied. Okay.
Wasn't a motion.
Mr. Bailey, you had earlier raised an idea that you wish to represent yourself. Do you want to represent yourself, or do you want to have an attorney represent you?
I got an attorney. You assigned it.
Sorry, I can't hear you, sir.
You assigned me an attorney. I got an attorney.
All right,
Talk to my
so
attorney.
you're withdrawing your motion to represent yourself, correct?
I never put in a motion to
All right,
represent myself.
then that's taken care of. All right, nothing further. This matter is completed. Everybody have a nice day.
Thank you, Your Honor.
All right.
Thank you, Judge.
Yeah, that one's going to be good. That one's going to be good.
Thank you, Mr. Penny.
This is
Judge, sorry for not being in person. I'm coming off of this cold, and I don't
Yeah,
want to be
it's
patient
nasty.
zero for anybody. Have a great
Well, I
day.
appreciate you. I appreciate you not coming. No offense, but
None taken. Thank you.
all right.
Have a
All right.
nice day.
Council, do you want candy?
I'm good, thank you, Your Honor.
Okay, all right.
Trying to stick to that New Year's resolution.
All right, sounds good.
Do you want candy? No, I'm trying to stick with my New Year's resolution. Okay, so with that, let me just tell you a little bit about this guy. So the trial, first of all, that trial is. Let me go back and show you. This is Mark Slavin's personal meeting room. It's Michigan, Judge Slavin. I don't know exactly the area.
They're finding him an attorney?
Yes.
Okay, but we don't need that anymore.
Yeah, because I don't even know which. There's two Jeffrey Perlmans, so I don't know which.
Oh, that's a different guy. This guy, it's a retrial. The first trial was hung before the holidays, the hung jury. His previous attorney had a falling out, and the attorney withdrew. He told the judge he wanted to go pro se. Now today he has an attorney. He has a trial for April 21st. First-degree murder, felony murder, armed robbery, felon in possession of a firearm, and 4 counts of felony firearm second degree are his charges. And he's got a public defender who was just assigned to his case, who is not happy about it. He's like, my client would like to put something on the record. I do not accept any of your trial date or anything else. Yeah, it's gonna be amazing. It's gonna be great. So we'll pencil that one in. Josh, once again, thanks for finding these. Those are great. Zimmy gifted a membership. Thank you very much. That one went to Gene Anderson. Congratulations, Gene. Judge Slavins and Judge Slavin are 2 different judges in the same county in Michigan. Oh, good. One of them has to be retired. I'm sorry, that's just too confusing. Yeah, he drew the short straw. Crazy. Wayne County, not Washtenaw. Pencil it in, please. Josh finds the best cases. He's phenomenal at that. He can sniff them out. The Slavinses. The Slavinses. All right. With that said, let me get set for our little court hearing that we're going to be going to here. Let's pause this for just a second. All right. This I have to do some audio work on this. This was a hearing from yesterday. It's a pretrial hearing, and I wanted to watch that because one part of this brings up some issues that might be interesting at court. So we'll see. Hopefully that we can get the audio working out a little better. It was terrible when I listened to it, so I apologize, but we'll see if we can. I haven't listened to all of it. I jumped around just enough to find out. I think it's going to be interesting. Okay, let's go here. The lighting on that seal makes it almost hard to read, but it does say the Great Seal of the State of Tennessee. I didn't know Tennessee had seals. I thought they were more Arctic. Just kidding. I'm just kidding. That's a joke. They're both on the bench. Yay. Let me get the audio system set up so we can try to tweak this a bit. It was a fark, not a farce. Yeah, I thought he said fart the first time, like with a T, not a K. But it was fark. Maybe he just dropped the E and didn't know how to pronounce it. We are going to have to take this audio and make it happen in both ears. Just 1 second. Make it stereo to play with it. There we go. Judge taking the bench. It's a little better. I hear chains.
Chen is in the courtroom. We've got a number of motions set today. I understand there might have been some logistical questions about the jury.
That's correct, Judge. I believe it would be a party-wide conversation just because some of the things that we talked about back in the jury room, I wasn't aware of, and so I know Mr. Weiss and Mr. Morrison were not either. So I just thought we could sort of go through the schedule next week, including sequestration schedule, and address any issues that we have before we start getting into the motions and
Okay. The way I understand it, we're going to start picking the jury Wednesday at 9 a.m. Nashville time. So Mr. Chen will be transported to Davidson County sometime Tuesday. The jail, as I understand it, is pretty much adjacent to the courthouse, so there will be a transport issue there. We'll, depending on how the questionnaire discussion goes, that will determine what happens on Wednesday. But at some point, we'll start picking the jury, actually engaging them in conversation, hopefully have that finished up by Thursday. Then the jurors will be sent home to pack, arrange their affairs, and the way I understand it, they'll be met Sunday in Nashville with our deputies. We'll then take them down to the hotel here. They'll be
Do you hear that?
in.
The jury will be sent home to pack.
Court Monday, and that's when they'll be sworn in. They will not be sworn in Nashville. As soon as you swear the jury in, that's when they have to stay together. That will happen on Monday. And then after that, it's just the regular routine sequestered jury. That's the overview of it. Are there any specifics the parties want to discuss more than that?
So the court
Anything I've missed?
will the court be instructing the jurors, and at 14 is what the court's decided. Will the court be instructing the jurors on Thursday that they are not to read?
Absolutely.
Okay, and then they would have to verify Monday morning that they have not done that?
Correct.
Okay.
Greeters, that's funny.
Anything else, Mr. Weiss? At this moment?
Not regarding the jury selection.
Okay. This is a fluid thing. If something happens, then we can always, we've been really good in the past about contacting each other during the trial to see if any issues pop up and handling before they develop into a major issue. So we'll just continue that process throughout this trial. All right. Any other questions about the logistics at this point?
No, except for I had mentioned to Your Honor that I don't believe we have to follow the motion. We had it prepared and I've read it. I don't know what happened to it. But both parties have agreed, if the court would agree, to keep at least one alternate juror sequestered throughout deliberation. In the event that deliberation is lengthy and if something were to happen to a juror, especially with them being further from home, just to ensure that if there is something that happens, there's another alternate that's been sequestered that can step in. I believe we're all agreeable for at least one, if not both of them, to remain in the courthouse sequestered.
I think that's a great idea. I think okay. I'm curious why we haven't done that before. Always got to start somewhere. Let's start with this. Okay. Any other logistical issues? Sheriff, you're here right now. Why you got the parties? I don't know if your team wanted, before we got to the actual substantive hearings today, if you had any questions or anybody from your team had any questions that wasn't covered.
I think we're good now, Judge.
Okay.
We'll be sure I'm bringing to the court's attention.
Okay. And again, if these things, if something pops up with a communication issue with Davidson County Jail or the courthouse, just let us know and we'll do our best to resolve it. All right. Thank you all. Any particular order of the motions?
Judge, I would say while we're on jury issues, I would ask to go ahead and get into the motion for a jury questionnaire to be given to the jurors.
Have you heard, Mr. Weiss?
Yes, sir.
Army Mom, congratulations on 10 months.
I believe the plan for a jury questionnaire was to get the questionnaire out to prospective jurors at a time that they were being summoned. Obviously, that did not happen in time. So I believe the questionnaire that I presented to the court within the motion probably isn't pragmatic or reasonable anymore because there's no way to get it out into the mail and get those answers back within the known time. Or at least I don't think there is.
There's no way we can do it before next Wednesday for sure. The concept I was thinking about, and I understand the state objects to the questionnaire overall, I said if we could possibly give this to them in the morning, let them fill it out, we could look at it in the afternoon. I don't know if that really saves the time that questionnaires are designed to save.
Well, it does. So one, it certainly does save time, but two, and more importantly, it gives an opportunity for prospective jurors to be honest. I believe the literature says that jurors tend to be more honest on paper than they are in front of a crowd of other people. You know, you ask a crowd of people, have you ever been arrested before? You know, people are hesitant or reluctant to say, you know, I've been arrested. Whereas if you put it in paper and it's not said in a courtroom full of people, you're more likely to get honest answers.
Great.
What I would propose to the court now is I have a preliminary new questionnaire drafted that is shorter and able to be answered within a sufficient amount of time. So on Wednesday morning, I think the prospective jurors could be given this questionnaire. They could answer it. I think it would take almost 30 minutes for them to answer these questions, and then give the parties an hour, maybe 2 hours to go over it, and that would give the parties an opportunity to object to certain jurors for cause, have them approach the bench instead of having to do it in front of everyone else. And I think that would save sufficient amount of time and get the best prospective jurors in this case.
Has the state seen your proposed shortened questionnaire yet?
No, I was working as of this morning.
Okay. Well, General, do you object to a shorter questionnaire?
I do, Judge. I would ask, first of all, how much shorter, but still, if you think logistically about how that would work. We did the numbers for the 11-page. If you have 75 or 85 prospective jurors, you give them an 11-page, 10-page, because it's actually 10 pages of questions. That's 750 or 850 pages that we would be asked to go through and try to pick out what's significant. Honestly, I don't even know if the state would really be interested in doing it, because you logistically you can't do that. I mean, you can't go through 850 or 750 pages of questions in a reasonable amount of time. And to the court's point, which the state does respond to this in writing, these are hours that we're talking about where we could simply be asking the jurors to, by show of hands, you know, has anyone served in the military? Raise your hand. And then Mr. Weiss can certainly go here on that question. It seems like, which way do you want to do? You want to ask the questions, or do you want to make them write it down? I also do believe that there's a confidentiality issue where a lot of jurors would actually prefer not to write something down, not to put something in the record, but potentially be able to approach the bench, like we offer them the ability to do if something is confidential. Maybe you wouldn't want to write it down, not to mention that we object to several of these questions anyways. But I think at this point, Mr. Weiss started with saying we originally had said we would send these out when jurors are summoned, but we didn't. Well, I mean, it's not the state that did, and the state didn't ask for the questionnaire. This could have and should have been done earlier so that they could have been sent out and maybe even follow-ups with jurors accomplished so that we had these back, or at least the majority of them back. It just wasn't done until 2 weeks before we're supposed to be going to Nashville. So we would object, but of course, this is within the court's discretion because it's a trial.
So there's a change of venue in this one. That's interesting.
I've never heard
from
any litigant, I've never heard from any judge that a questionnaire had ever been a waste of time. Every
Josh, thank you so much for the gifted memberships.
Court that I know that have used these questionnaires have found them enormously helpful. I have my questionnaires now down from 11 pages to 4, so that should eliminate 75% of the amount of material that I have to go over.
I believe this is defense speaking right now.
You know, maybe people are concerned about the confidentiality. They can simply write down on a piece of paper, I would like to approach the bench about this, and I can answer it on paper. That's perfectly acceptable too.
But I think the way these are, the questions are usually done is that there's an extra day. I know for the death penalty case, we bring in the jurors for an extra day. They fill out the questionnaires. They get exposed to the case a little bit at that point, and then they get. So in this particular case, in an effort to see if we can pull it off, I called the clerk, and there would have been difficulty getting this questionnaire to them without bringing them in for an extra day. And so I think it would have been really difficult to pull off, even if we did it earlier, unless without scheduling another day. I think where we are right now is that it's either going to be a questionnaire that they can do, clearly can do within 30 minutes, that might be helpful to the parties, or we just don't do it at all. I'd like to see the questionnaire myself.
I can have that submitted, I can do it formally through an email if what the first, or have it about tomorrow. Or I have it sent tomorrow.
That's fine, let's do that. But in any event, the parties need to be ready to be at the Davidson County Courthouse at 9 a.m. Central Time to do voir dire, whether it's to introduce them to parties and hand out this very brief questionnaire or to start playing. Okay. So that'll be taken under advisement.
There were, one of the motions that Mr. Weiss called had to do with the defendant's rights under the Fifth Amendment to not testify. Of course, Your Honor, the state would always comply with that. The state agrees that the state cannot mention anything that would involve the defendant's Fifth Amendment rights. So that's an easy one we can agree to. I believe that there were a couple others like that. Mr. Weiss, you might want to bring them up.
On that particular motion, but the motion will need to exclude the reference to defendant's silence. Is that what we're talking about?
Yes.
And not only just as a right to not testify at trial, but pretrial silence.
That's what I thought we were kind of getting into. I'm learning a little bit more about the evidence that you guys are aware of, and I'm learning about. There was a video apparently of Mr. Chen at his parents' house, correct?
Yes, and I have that video ready to play.
And there was another video of him in jail clothes. Is that correct?
That's correct.
So my question, I was reading this, of course, this seems to imply something beyond the normal prohibition against the state commenting on defendant's silence. So I thought, is there a video where he's silent and the demeanor is somehow relevant and that's what the state's trying to get at? Or is this just a standard motion not to comment on the motion? Okay, well, it's the same. Bye.
Getting this groundwork laid out for the case.
This is a motion regarding the state's use of Wi-Fi.
So apparently I'm the only one that can't access the Wi-Fi. So I will strike that motion.
Motion stricken.
Those may be the only ones.
Defense can't use the Wi-Fi?
An agreement on, Your Honor. So
Give him like a guest network or something?
We can begin to go through the other.
Court appointed interpreter seems an easy one as well. I called the AOC, and I did contact you, I think. The AOC does not cover interpreters for victims or defendants' families at trial. So, did you want it at trial or just at the sentencing hearing?
Isn't sentencing part of the trial?
Move the.
In the case of an LWOP, life without parole, we're going to have a jury here, and I have witnesses that I intend to call that don't speak English. I don't know how the court, if my client, or if the court does not appoint an interpreter in accordance with Rule 42, I'm going to have my client's brother translate for them, for the jury.
Can't do that.
So, again, there's a difference in having the AOC pay for an interpreter that sits through the guilt or innocence phase and having an interpreter sit through the penalty phase. So I can tell you right now that the trial phase will not be covered. The sentencing might, but you're saying something different.
Let's make sure, because I'm not sure that we're clear. I am not asking for an interpreter to interpret the testimony that occurs during the trial to people, to my client's parents that are sitting in the gallery. I'm asking for an interpreter if either of the defendant's parents were to testify at the sentencing.
So okay. That makes more sense to me. So the interpreter would simply be to interpret
to translate the
your
witness's
client's
testimony.
parents' testimony so we can understand. Okay. Let me, I'll call the AOC on that specific issue, so I'll take that under advisement.
And according, I believe it's section 7 of Rule 42, says it is specifically paid by the state if it is during the course of a trial. And I would say that the sentencing phase is the course of the trial and held on.
So I'll bring that up if they say no. Not correct. Thank you, Mr. Ward.
Let's see what else. I don't want to, I'm walking back here because I don't want to move my laptop because it's all set up to play. The next motion is defense filed a motion that Jasmine Pace not be referred to as a victim throughout the course of the proceedings and throughout the trial, and that she be referred to either by name or by decedents. The state has produced case law that says that it's basically judicial discretion. There's 2 or 3 cases I found.
This motion is to call the victim anything but victim during the trial.
The decedent, or whatever you want to call it, as the victim.
Call her the decedent, call her by her name, but they don't want anyone to refer to her as the victim.
To use your discretion, and we ask the court that Ms. Pace would be referred to as Jasmine Pace or the decedent.
This is, my understanding of the case law is that the problems come when there's a dispute on whether or not the victim was actually the victim, whether it's a self-defense case, whether it was simply an accident. I don't think the defense is arguing that a murder did not occur. So I do think that in this particular case, based on what the case law I've read indicates, the issue that prevents a person, or that should prevent a decedent being referred to as a victim, isn't present in this case.
Good call, Judge.
Does the state want to be heard on that?
Your Honor, to the extent that the state would refer to Ms. Jasmine Pace as a victim, that's a theory of the state's case. We submit also that the jury would be instructed, following such comments, at the conclusion of all of the proof, before they are charged to begin deliberation, that comments and statements of counsel are not evidence, that they are the triers of fact, or that they are the ones to decide whether the defendant is
The state says we're going to call her the victim throughout the trial.
Right,
That's a theory of her case. That's good. If it were a self-defense situation, it would be different.
The law enforcement with Hampton County and I believe it's the Nolensville Police Department executed a search warrant in 1942 National Court in Nolensville, Tennessee. During the course of their search, they took pictures of, I believe it's the desk in the bedroom of Jason Chen. And some of those have notes that we believe are protected by attorney-client privilege. And also, we also argue that they are not relevant under 403. And they don't have any probative value, and it's overly prejudicial. And I have those pictures ready to show the court.
State will be heard.
You're saying during the search warrant, they took pictures of the desk and had documents that should be protected.
There are certain portions of the photographs which will be shown here shortly. I also have them printed.
Oh, here.
Your Honor, I think by the agreement of the parties, we would submit photographs in question with the exception that the state has placed proposed redactions to material that we think would be objectionable, specifically, I guess, notes that you would describe as possibly statements about conversations with possible counsel, dollar amounts, it looks like. So we would submit this as a collective exhibit for the court's consideration.
I'd like to exhibit 1 for this hearing.
So during the search warrant, they took pictures of
it's not objectionable, it's not unfairly prejudicial.
paperwork that might be attorney-client privilege. The judge is going to decide if it gets to be submitted or not.
I can provide these in digital format if the court finds it difficult to read.
You can refer to them if you've got a copy in front of you want to put them on the screen. Just make sure I'm looking at the same posted. You are certainly do that. Want the defense laptop?
Yes, please.
might get to see these pictures. This might have something more to do with cost of attorneys and things like that. There we go.
So so this is the unredacted version, which is different than what the court has in front of it. Some of these notes have conversations or notes that we believe that the defendant has written and after having conversations with potential counsel, and we believe that's what all these notes are relevant to. So based on that, we would ask for all of the pictures of these notes to be excluded in total. If the court, otherwise, in the alternative, we'd ask the court to go through each note and choose which ones to redact if the court finds it in violation of Rule 403 or if it's protected by attorney-client privilege.
So, General, to understand you, the redacted aspects are aspects that the state agrees should be redacted, or?
Yes, Your Honor, and if we could, I guess, zoom in on, for instance, on, go to 276, Judge. Next one. One more.
So the state knows some of these are attorney-client privileged documents.
Yes, Judge. So
they're redacting
if
some
Your
of
Honor
them.
were to draw your attention to the purple note towards the center of the screen.
Yes.
And Josh,
My copy's redacted.
correct. And if Josh, what would you like to?
Oh, wow.
Your Honor, it's got a phone number there. I recognize that to be a phone number of counsel. I don't know that it necessarily
The attorney's phone
mean
number.
anything to a layperson looking at the evidence, but with abundance of caution, the state did black that out because it is, I guess, indicative of somebody reaching out to an attorney.
I mean, if the state agrees that the blacked out portions should be redacted, we can just talk about the things that Mr. Weiss thinks should be redacted and the state doesn't. I guess we'll go through it post-it by post-it then.
Yes, sir. The first picture here is, I think, just showing all the notes, and then in the subsequent pictures, you can see the notes.
So we're looking at everything to decide if the jury gets to see these during the trial.
I don't know what relevancy this would have to the case. Obviously, it doesn't have any attorney-client privilege information, but
Relevance is a pretty low burden.
Right hand, right finger, middle finger, index finger.
I mean, the simple fact that they're organized notes that have something to do with his life at the time, in context with these other notes. Apparently your client thought it was relevant. So again, 401 and 403 is a very low threshold.
I think all these should be excluded. We're not the formal jury, though. There's zero chance I'll be on this jury. I'm not in the jurisdiction.
the note here on this next to the purple note.
Hang on just a second. Is there a photo? I'm looking at page 3 of Exhibit 1.
It says she has a long history of running away from her parents. I believe that's in reference to Jasmine Pace. I know relevancy is a little bar, but I believe that's overly prejudicial and it's not relative.
If it has anything to do with the case in general, has some bearing on a consequence, has some consequential bearing upon fact that's material, and the danger of unfair prejudice does not substantially outweigh the probative value, then it should come in. I don't see where the danger of unfair prejudice applies to that note.
So one note's coming in at least.
Above that, it's, you see where it says Crawford and the phone number. I believe that is the phone number for that lead investigator case, is that Crawford? Okay. I think that's overly prejudicial, but I don't know.
The lead investigator for the case?
Yes, sir.
Clearly the lead investigator to the case has some relevance to this particular case.
The judge is mumbling.
Overruled.
In this, I don't have the redacted copy in front of me, but in the upper left-hand corner, we're on the next page, Judge.
Okay.
It says, I need a legal, is this what redacted for? I need legal consultation, a potential suspect in this first case, and it says, I know let's see.
I got it pretty, it says I-N-N-O, so you presume it says innocent, or would have said innocent, perhaps.
I know I'm N-O.
Asking for that to be.
What does invoke getting a lawyer, general? I mean, it's not, I suppose the analysis is whether or not it's privileged.
That is indeed the question, Your Honor. It reads more of a script of what he intends to tell somebody. It's not a privileged communication in and of itself. I would submit that on the note to the right, there is a name. It says Ben McGowan, which the state has agreed should be redacted. I think that's the spelling of a local attorney here in Chattanooga, which, again, I don't know that jurors from outside of the county would have any inkling who a Ben McGowan is, but I would submit that the note on the left is extremely probative. It's not my lawyer told me 1, 2, 3, 4, 5. It is rather a script. It's a statement by a party opponent.
It seems to me that a fair interpretation of the note in the upper left, again for the record we're talking about, page 4, exhibit 1, the note in the upper left, seems to be a script what Mr. Chen would have told his attorney. I think it's borderline. It probably does not qualify as a privileged communication because he's not saying that to his attorney. But I think it's a fair interpretation of something he would have said to his attorney. I'm inclined to grant the suppression of that upper left note because it does seem to be.
Wow. I'm surprised they're letting any of these in.
And getting representation. I think that's a little too close for my comfort, so with the defense motion to redact or suppress that particular upper left note on page 3 be sustained.
The next note directly below it, I believe, is a continuation of that same script.
This seems like it has the risk of appeal written all over it. Why would you flirt with that line in a murder trial where you've got notes that are clearly talking about the defendant talking about his defense, which may or may not have been taken while he was talking to his lawyer. He might have been writing down something that they discussed. He might have been writing down questions to ask his lawyer, to present to his lawyer. That just it throws a big question mark over the verdict if these come in.
I think that's more arguable. I think that's something that could have been written. It's less clear that was written in preparation. I think the upper left note taken in context with the one in the upper right is
I think
clear.
I think a taint team would have thrown all these out.
Lower left note. Perhaps taken in context, it might be a script that he was going to talk to his lawyer about. But since the upper left note will be kept from the jury, I don't think the lower left note runs that same risk. So let the defense motion to suppress the lower left note on page 4 of Exhibit 1 be overruled.
On the right side of the picture,
Overrule that one that's coming in.
The state has already agreed to redact the name of Ben McGowan. And a note below that, the yellow highlighted colors one, the state has redacted the 7,500, but below that are, I think those are just statements of law. I don't know how those are recorded.
So for this to be an appeal issue,
My copy is redacted. Ben McGowan.
these would have to come in during court.
Top right, Your Honor. Okay. Look at the lower right.
And if the state has to bring these notes in to help prove their case,
This part here
is their case really that strong?
What do you think, gentlemen? That's something where I suppose the argument could be he got that off the internet, but taken in context.
Sure, I think it also goes to guilty conscience, Your Honor.
Goes to guilty conscience? We'd like to include the fact that he was looking for a lawyer to prove that he was guilty? Did I hear that right?
I'm not quite sure how that would show. I would need an explanation about how that would show a guilty conscience. I can say those two things objectively, and that have no bearing or relevancy to this case.
It's like only guilty people get lawyers is the insinuation
I think
there.
fair reading, it might have come from conversation with an attorney who was Ben McGowan or attorney. This doesn't seem like something that, I mean, that's correct. Maybe it's not agreement in 14 days. Perhaps that's something he could have gotten off the internet, but taking the context of the others, go ahead.
I would submit that he has not been arrested yet, Your Honor, so he's clearly contemplating that is going to happen, that he has a guilty conscience, and obviously when taken in context with that note that Your Honor's ruled on is that I think he's acknowledging how this is, in fact, there is evidence that shows that he is guilty of crime and therefore will be arrested.
This is
a statement of law, like entitled to a hearing in 14 days. It's a preliminary hearing, police have to show probable cause. It doesn't seem more of a statement of fact. Any response to that? Other than what you've already said?
No, Your Honor.
All right, the defense motion to suppress the lower right note on page 4 be sustained.
Okay, so that one's staying out.
Page 5.
This next picture is the posted note with the name Ben McGowan, but it's the full note. I believe the court has noted that that's admissible for other reasons. And then here in the lower right-hand corner, you'll see another note that we've seen on the next photograph. It says,
entitled to hearing 14 days.
Talk to her mom on the 26th. Premeditation, death threats, breaking and entering, and missing person yesterday.
I read that saying defamation.
It does say defamation.
Seems to me that's, again, speculative guess, but might be what negative aspects of his situation might be. He's getting defamed, getting death threats, perhaps. What do you think? Does that change your analysis where it says premeditation versus defamation?
Either way, I didn't think it was relevant.
General, what do you say?
Your Honor, I submit that for the same reason the court found statements about Saturday, November 19th, last time I saw her. Again, it's a submission by party opponents. It also corroborates certain pieces of evidence. In this case, Your Honor may recall during the motion to suppress Officer Pierre's body cam video, where there's a telephone call between Ms. Trina Pace and this defendant. This note right here, I talked to her mom on the 26th. That corroborates that was indeed his voice. So that makes it extremely relevant.
I agree with you with the top part of the sentence. I'm talking the second part with the defamation, death threats.
Sure. Your Honor may also recall that there was testimony by Investigator Crawford that the defendant's cell phone placed him in the area after the search by the Pace family. That indicates and corroborates the fact that he was in fact there. If he did not return to his apartment, how would he have known of breaking in and entering? Furthermore, Judge, one of the recordings that the state has in its possession, which the defense also has in its possession, is a phone call, again, recorded, where the defendant is complaining of people threatening him. So I would submit that on that, under 403, it's not unfairly prejudicial. This corroborates and identifies him in other pieces of evidence.
I think the top part of the note definitely comes in, but the second part seems that it might be something that his attorney instructed him to do, or talking to an attorney, I guess either Ben McGowan or someone else. I don't know if
this just seems dangerous.
Mr. Chen would have gotten defamation, off the internet, but it seemed like something a lawyer might have told him to let the defense motion to suppress the bottom half of the bottom right note on page 5 of Exhibit 1B sustained.
You mean top right? I don't know how you're
Like this bottom right, the defamation. Oh, I was looking at page 5.
It's the same note that you're looking at, it's just the full note.
So I guess looking at page 6, yes, looking at page 6 of Exhibit 1, it would be the top right note. So let the first sentence should come in, talk to her mom on the 26th, but the line below, defamation, death threats, breaking, entering, the defense motion to suppress that one statement be sustained. And then I wasn't looking at this bottom line. It says missing person yesterday. Either side want to provide more information other than those 3 words.
That's all we got.
There. That seems to be less legal, what comes from a lawyer, and more something he might have gotten from following the news. So the only thing that will be suppressed on that top right note will be the middle line, the middle entry of defamation, death threats, breaking in and out.
The note below that, Your Honor, the state has agreed to redact the top portion of it, where it says the the phone number and the address, and then the number of the circular in the middle. However, you can tell from the context of this note that this is a conversation with this attorney. Notes that are made are obviously notes from the conversation.
If I read it correctly, it says November 19, last time I saw her, she would call me. Last time was on, she would call me once a day. Last time was on November 22nd on phone. That seems more in line with the other notes that came from Mr. Chen that have already been ruled admissible. Seems more in that line, Mr. Wise. Anything else you want to say about that one that hasn't been said?
Starts in just under 2 weeks.
Otherwise, the state's redaction is just an agreed upon, and the rest of it's listed. And then here's the last one. This is a note in a notebook. You can see the name at the top of the bank account and his phone number.
This is page 7 of Exhibit 1.
They're still arguing about different notes. They've got phone
See,
numbers,
Friday, November 18th,
names
last
of
time
lawyers.
I saw her Tuesday, November 22nd. Last time we talked, she has a huge history of running away from home in her teenage years. Mom was an alcoholic, ran away, let's say, to Canada for several years and was homeless.
So imagine.
See if anything under the strictly through language is legible, so something has a restraining order against her ex.
Imagine the lawyer said, write down everything you can about the victim that I should know. And he did. This whole thing's attorney-client privilege.
X, okay, X. Says she was recently online on Facebook. Again, that seems more in line with Mr. Chen's recollections rather than
The state has redacted a portion at the top, so we obviously agree with that. We asked for a remaining portion.
We're going to redact the lawyer's number on the top, but everything underneath is coming in.
About Mr. Chen's interactions with the victim. It seems this falls in that same category as the defense motion to suppress the notebook entry on page 7 because it won't be overruled.
It's coming in.
And then,
wow.
Going back to like the first picture of it, there's a picture of all the notes. So I would ask that the portions of the court has ordered to be redacted and the parts that are redacted by agreement will just be redacted on all copies shown in the picture.
Yes, Your Honor. I'll submit the proposed redactions this evening.
This motion also references the video.
I think this is bad. I mean, this guy might be guilty as sin, but
That motion references it.
this is wrong.
I'm looking at the one with the search warrant. The style of motion looking to exclude defendant's statements in video. That's something different than.
Yes. That, so I'm just to give the court some context. The defendant was arrested at his parents' residence in Owensville. There was one officer that had a body camera that captured it. It is not an official interrogation, I would say. However, there is no question that the defendant is in custody, which the state agrees with. The relevancy of playing this video, or there is no relevancy to playing this video. It's overly prejudicial. There's a waste of time, and I don't want the court to get into it in front of the jury. The video is about an hour long, but I believe it's only the first 20 minutes, 25 minutes. That is relevant.
Gentlemen, before we play the video.
The state reserves argument.
So the defense attorney is not arguing when the judge makes a ruling because he's filed the motion. It's preserved.
All right, you'll go recording.
So this is a body cam video of when he's arrested at his parents' house, I believe. Defense has said it's too prejudicial and it's a waste of time. The notes have attorneys' names at the top with their phone number and the price they charge for their services. Thanks, 80s. It's so dark I can't even see the timestamp. It's like 2022. Possibly November 29th, 2022, is that right? Maybe 2023? It's hard to see. It's either a subtle ending or it's a body camera arrest video, one of the two. We're not sure which.
Only at that.
Are we sure the doorbell worked? Or did we knock or something? Okay, there was a knock in police. Door open.
Did you talk to your son, Jason? Understand the translation of that?
She says, I don't understand. Police said I need to talk to your son, Jason. She says, do you have a warrant?
What language do you speak? Chinese, Mandarin?
Call the lawyer.
We have a search warrant come outside. Yes, we had a paper. We have a search warrant for your residence outside. No.
Whoa.
Your wife can come out and don't like to.
We have a search warrant for your residence. We'd like you to come out. The police asked if they have a translation app, and I tried to use that to communicate. Sounds like they called someone instead, and the person on the phone is translating. There's Jason there. The officer with the camera on his chest is like 4 people back, so he's got no view and no audio. Police are still trying to negotiate the family stepping out of the house so they can do a search inside it. Not sure if that's his brother or the defendant, actually. Looks like the family's agreed to put on their coats so they can step outside because it is cold. Police are coming in. Looked like the defendant, as he was putting his coat on, went to go deeper into the house, possibly upstairs, and the police followed him and are now trying to tell him, no, don't do that. It's 7 minutes to midnight right now when this was filmed, according to the body cam. They do have a warrant. So the parents and the son are going to be pulled out of the house, and then the house gets searched as well. It's some warrant. Before they even arrest him, they've got a warrant for the house. We're going to pat him down, so I'm going to search you really quickly. Still doing translation, explaining what's happening with the searches and everything else. This entire video is an hour long. I imagine that most of it's at the door here. Detained, not under arrest.
Correct, yeah, it's for search warrant for your person, so we're, Louisville Police Department, we're gonna be detaining you, you can watch that search warrant. We're assisting Chen to do it.
Oh, yeah. And, is there any, like, probable cause or anything?
They'll explain that, they're gonna explain that to you, that's it, yeah. We're gonna let them do that, but I don't wanna speak for them. Yeah, we don't want anybody to misinform you of anything, so they'll tell you all that when we get down there, so just take it from them. They're the lead on this, you don't want to know from us, so yeah, we know it's legit. We wouldn't be enforcing it if we didn't think it was, we didn't know it was, but we'll let them explain it because we don't want to pile on information. We'll let them one time it only, you know. Okay. All right, so if you will, just face away from me. All right, do you have any other person? Drugs, weapons?
So he says, when they say we're going to put you in cuffs and put you in the car, he asks, do you have probable cause?
watch the entire interaction, Your Honor.
Okay. You just have to listen to 20 minutes of it.
I would move to enter this as exhibit number 2 for this hearing. I have a flash drive and I'll provide it to this witness. Your Honor, this video should not be admissible at trial for a variety of reasons, as I've stated in my motion. It shows the defendant in a state of undress. There is no Miranda warnings. It's questionable whether or not these are voluntary statements to law enforcement. Law enforcement is using my client as a translator to communicate to my client's parents that they have search warrant and they're coming in because of those issues. And then Mr. Chen here is trying to understand why it is that he's being taken. There is a search warrant, but there's no arrest warrant. So there is some confusion of whether or not he has to go with police or not. So just trying to understand it. But the most important thing is the placing of handcuffs, the executing a search warrant, in no way makes any other issue or fact in this case more relevant. The probative value here is substantially outweighed by the unfair prejudice, especially with showing the defendant being placed in handcuffs. I just don't know what the purpose of making this trial would.
John, I have a few concerns about this one. It seems like there is a legal discussion going on where Mr. Chen asks about probable cause. He wants details about it. The fact that he is speaking in Mandarin to his parents. I'm a little concerned if, I don't know what that translates into, and there may be a juror who thinks they might know a little Mandarin enough to maybe make a mistaken interpretation of what was going on. So I've got a few concerns about this video, but I'd like to hear your thoughts on it.
Sure, Your Honor. Let's start with the constitutional challenge raised by the defense under Miranda. Miranda applies to custodial interrogations, which creates a two-part analysis that the court has to look at. First, was the defendant in custody? And secondly, were the statements the result of an interrogation? I think that the court candidly can take notice of the fact that a reasonable person being placed in a police car, being told they can't leave, that they're being handcuffed, would create a custodial situation. The question is whether or not the statements that were made by Mr. Chen were the result of an interrogation by law enforcement. The law on that's fairly clear. It's questioning or statements, words, actions on the part of the police, not the defendant, the police, and not the defendant's family either, that would reasonably elicit incriminating information. The defendant hasn't made a challenge to the content of the statements to his parents. Obviously, the defendant is in a far better position to understand what is being said between him and his parents and to lodge an objection to whatever that is. I understand the court's concerned that there might be individuals who speak Mandarin on the jury.
Let's say I agree with you on the custodial aspect of it. Let's look at the relevance argument on that. The danger of unfair prejudice is what I'm looking at this, which might substantially outweigh any probative value. I see very little probative value, and I see, you can please let me know what I'm missing. I think there is some more there. I do think there is a potential danger of substantial unfair prejudice with the defendant discussing legal terms. Like, how's the jury going to take that? Are they going to think he's a pre-law major? Are they going to think that he's been educated about this in the last week? The fact that unless we get a translator to what gets said, what was said between Mr. Chen and his parents, that's basically sending testimony or statements from the defendant to the jury that we're not going to know what they are. So, as far as relevance and the danger of unfair prejudice, I'd like to hear your thoughts on that.
Yes, Your Honor. I would submit that there's actually two separate inquiries that the court needs to look at. The relevance of statements, the audio portion, and then the video portion. But first and foremost, the state would submit that this video is relevant for several reasons. First off, it places the defendant in the place to be searched, the Nolensville address attached to the report. He's also wearing a very distinctive hat. Your Honor, you can see that in the video. It's red and white. That will come into play throughout numerous pieces of evidence that will be introduced during the course of this trial. In essence, it's a form of identification. Also, the defendant's demeanor is relevant to the trier of fact in this case. So I would submit to the court that the video itself is relevant. The question then is, well, is the audio more relevant than the video? I would submit that if the court is inclined to grant the defendant's motion, that the court also needs to look at whether or not a video of a defendant wearing a particular article of clothing, which the state would proffer to the court, will be seen throughout numerous other video recordings of different locations on different days. That is highly relevant, highly probative. And 403, Judge, is really a law, a rule, if you will, favoring the admissibility of evidence. In fact, excluding relevant evidence under 403 is an extraordinary remedy that should be used sparingly, and that persons seeking to exclude otherwise admissible relevant evidence have a very significant burden of persuasion for Your Honor. The defendant in his motion says that it's marginally, of his words, marginally probative. The state would submit that it's significantly probative. But in light of that, Your Honor, the question is, the burden is on the defendant to demonstrate that the defendant's video recorded statement captured during the initial interaction between law enforcement and him at his residence in Nolensville creates a prejudice that substantially outweighs the probative value of that video recording. So I would submit that on that basis, Judge, you have to look at it both for the entirety of the video, including the visual portions, but also the court is very well aware that audio can be redacted from video recordings, and sometimes that is what the court rules.
What probative value would be lost if a still from the video showing Mr. Chen at the door of the Nolensville address while he's wearing his red hat, if that were to be an exhibit? What does the state lose from losing audio and video? If that were to be an exhibit?
The defendant's demeanor, the clarity of his face. Your Honor, can see the lighting is very poor, so we'd be picking, in essence, having to choose between a very distant shot of the defendant descending the stairs or in close proximity to the staircase where it's not clear, or a much clearer image of the defendant's face, but it's under the, the entryway of the house where it's very poorly lit. You can see his face much clearer, but you can't see the hat very clearly. So in essence, it would be forcing the state to choose between two not so great options.
So, again, can you tell me why his demeanor is relevant in this particular case? I mean, would it be more relevant if he was, or less relevant if he was excited, less relevant if he was more subdued? What relevance does the demeanor in the video have to
courts recognize the coolness of fact after a violent homicide is evidence of premeditation. Being confronted by law enforcement officers with a search warrant for his residence, Your Honor has seen it, he's calm, he's collected, he's not at all worried, not concerned to any degree other than, do you have probable cause? It's curious questions for somebody who professes his innocence in his writing.
Let me heard on that.
Yes, Your Honor. I believe there is a picture, I'm trying to find it now, that Nolensville Police Department took of Jason Chen when he was detained, and I believe that he was wearing that red hat, in fact. What's that?
going to show it to the court. So if the state needs to be able to show this hat because it's important to their case, they have this picture, which should suffice just the same. This picture is better than any still that you can get from that video.
And so I'm clear, is that the picture that was taken when he was taken to the Nolensville Police Department?
Yes, sir.
From the house?
Yes, sir. So they have a picture of the hat. That can't be an issue. The video needs to be included with that. And then, most importantly, my belief is the state wants to introduce this because they want the jury to see the defendant arrested, placed in handcuffs, and transported to, eventually to the jail. Because what does that give the impression of? It gives the impression of guilt. Watching someone get arrested and be placed in the back of a cop car gives the jury the impression of guilt. That's why it's an unfair prejudice. There was nothing said, at least nothing today, that was incriminating whatsoever. There is no probative value to that video whatsoever. The only thing that the state has drawn upon is the marginal probative value of his demeanor. And I think the court kind of hit it right on the head. What if he was excited? What if he was scared? What if he was calm? No matter what his demeanor is, that would make the video admissible. Because he's calm, 6 days after the alleged killing of Jasmine Pace, I mean, it's been 6 days since that point. So what type of demeanor is he supposed to have? So I don't know where the probative value comes in, even if it is, it's marginal, but the unfair prejudice, this is what the Rule 403 was made for, was to exclude videos like this.
What I'd like to do, I do think that there is danger of unfair prejudice in that video. What I'd like to do, General, is if you could provide a 30-second clip of what you think captures a demeanor interaction with the red hat. Obviously in the place to be searched, and I think that's pretty much as far as I'm comfortable going with this video. I do think there's a danger of a substantial danger of unfair prejudice for some of this video. That doesn't mean the whole thing needs to get excluded. So if you could develop maybe a 30-second clip that covers that, and I could review it and make a ruling on that later.
Yes, Your Honor.
Take that under advisement. Okay, I'll take that under advisement.
Okay. Moving on. The next motion involves the, I don't know if the nomenclature is going to be correct, but the message that was sent allegedly from Jasmine Pace's phone to Katrina Pace's phone containing an address or location influence. We have previously litigated that issue. I can provide an exhibit, but if the court wants to take judicial notice, this is the same picture that's presented in a motion to suppress evidence. The state has provided the defense 2 photographs of a phone showing a pinned location. The defense has never been provided anything other than that. So in these situations, I would have expected the state to have done an extraction of the phone and provided digital forensic evidence demonstrating that Katrina Pace actually received this message, where it was received from, and when it was received, how it was received, all those things. I've received no information that verifies that a pinged message, even from the service provider, that went from the Jasmine Pace's phone to Katrina Pace's phone. And in addition to that, we're alleging that it's hearsay. We're alleging that it can't be authenticated. We're saying that it's not the best evidence. And for those reasons, that these messages should not be admissible unless the state does the things necessary to properly exclude it from hearsay, authenticate it, and provide it to defense counsel.
Well, I mean, I guess this would be kind of a pretrial ruling on something that the state could clean up, perhaps between now and trial. I know that some video and text evidence can be authenticated without having the person from T-Mobile or Facebook or wherever to be here. So I think that it's possibly something the state could do. I don't know if that's something they want us to do. General, I mean, are you planning on using this for anything other than a non-hearsay purpose?
No, Your Honor, and the state did respond to the defendant's motion in limine on this issue. We don't believe it's hearsay for multiple reasons. The first and foremost being that it is the best example I can think of effect on the listener. The reason why the state has already introduced this evidence, at least once, if not more than once, is because Jasmine's family was looking for her. They did not know where she had been killed until they realized she had dropped her pin. That is what led them to go to Mr. Chen's apartment building. If you don't introduce this to the jury, there's this hole of the jury wondering, well, wait a second, they're looking all around town for Jasmine, trying to figure out where she is, how her vehicle got from here to here, where her vehicle was in this weird location where they believed it was, and then all of a sudden they are knocking on Jason Chen's door. The effect this had on Katrina Pace is why it's being introduced.
And again, I think what I'm reading here, there's two different arguments from sides. Where the defense is saying that it should not be admitted for the truth of the matter certain, but the state's saying it's not being admitted for the truth of the matter certain.
It is not.
Mr. Weiss, you have a response to the non-hearsay objection.
So let's make sure that it is a hearsay statement. You have to understand that there is a message allegedly from Katrina Pace, from Jasmine Pace to Katrina Pace. That message in and of itself is a communication, it is a statement by an out-of-court defendant. So
depends on how it's used. I mean,
but so if Jasmine Pace did send a message, and it was communicated, so that does make it hearsay. And then the information contained in it, if it's being used for a non-hearsay, I don't understand how it would be used for a non-hearsay purpose. The purpose is to communicate my location. That's why you send a thing, is to communicate this is where I am now. So I don't understand how that is a proof this is where I am. So what other purpose could it be?
Well, you can argue that a limiting instruction to the jury that's not to be used for the truth of the matter asserted would not be sufficient.
I don't think those work.
The general has argued is a pretty clear and I think common non-hearsay purpose. If someone says, I think the guy who did it ran in the house, that can be used to explain why the police went to a particular house. It doesn't mean that the guy who did it ran to the house, but explains why the police went there. And so it seems like this is pretty much along the same vein of explaining why something was done. As long as the jury gets a limiting instruction that's not to be used for the truth of the matter asserted, but only to explain why, in this case, the Pace family went to Tremont, that seems pretty textbook, not hearsay.
For only the hearsay issue, not the rest of the issues that of the motion.
So I'll say it to you the way that I understand it. Please correct me if I'm wrong, gentlemen. The state's not going to say Jasmine Pace sent this text to her mother, and it clearly establishes she was at Tremont at that time. They're not going to say that. The argument is going to be they were at, I believe, at a Waffle House, perhaps, if I remember correctly. They saw a text on her phone and a pin drop from this location that explains why they went to Tremont. And that's it.
And the court would give a limiting instruction on hearsay.
Yes, sir.
I understand that.
Okay, is anything else that needs to be said on this that hasn't been said yet?
Well, I would like to go ahead and address authentication, Your Honor. The state doesn't see this as that complex of an issue, especially when you consider Rule 901 and the law that's attached. And again, this is sort of spelled out, but I think in these courts and in courts across the state, it is often, and I cited cases that are directly on point, we often use pictures of someone's phone or screenshots from someone's phone as evidence. The example I gave in the response is that if someone takes a screenshot from Instagram of a person holding a gun, well, we don't exclude that because we don't pull the phone up and put it on the projector in front of the jury. We accept after it's authenticated, so we have to have someone on the stand that can say, this person is so-and-so, so-and-so, this was the Instagram account that was associated with him. We are going to have a witness who had her daughter's cell phone number in her phone. She had her named as her daughter, Jasmine, which is what she called her. She is going to testify that in her phone in that text conversation that it was not a text message, it was a shared location. She may or may not actually be able to pull it up, but that's not the standard here. The standard is that she pulled it up for law enforcement officers. Photos were taken of what she pulled up on her phone, and those photos have been given to Mr. Weiss. They will be properly authenticated. I understand that they're not. Certainly there can be an objection, but this is standard in the course of evidence introduced to juries, is that she pulled it up, the photo was taken. It is the best evidence. It is the photo that was taken of her phone. We don't ask witnesses to take their phone out of their pocket in trial. We certainly don't turn over a witness's phone to the defendant, as has previously been requested in this case. But that's just not how, frankly, it's just not how it works. And so this is evidence, it is relevant.
I think I agree that for the authentication purpose of the non-hearsay, all you need is Trina Pace to say, yes, this is what I saw that led me to go to Tremont. I think Mr. Weiss's argument would be, I think better placed if the state is trying to say, this is from Jasmine Pace, and it shows that she was at Tremont, then there would need to be another level of authentication to show that but that's not what the state's offering.
That is not. The line of questioning is exactly what the court assumed, which would just be, was there, Ms. Pace, something that led you to want to in Tremont? What was that? Simply. That is, in fact, the reason it is not the truth that matters, sir.
Based on what the parties have argued that this evidence will be used for a trial, which is a non-hearsay purpose, I do believe that the evidence can be authenticated through Trina Pace. So therefore, the defense motion to exclude the text message for the non-hearsay purpose be overruled. Mr. Weiss, if for whatever reason during trial starts getting spun in a way that it's argued for the truth of the matter, sir, you can certainly renew your objection at that point.
And just for the purpose of the record time, Judge, if you would reference whether or not this message would be excluded according to the Rule 1002, because it's obviously not the original. And it's not a rule of exclusion, which is true, but it is not the best evidence. And the best evidence in this case would be forensic data of that text message download, proving and verifying that that message was sent. And without providing the best evidence, without providing the original evidence, it puts that the forensics in the state's in doubt.
For the non-hearsay purpose that the state's offering for the best evidence would be the actual cell phone. You don't need any type of official report from any company for what the state is using it for. All you have to have is Ms. Katrina Pace say, I looked at this text and it caused me to take my family to Tremont.
No, that's for the 901, that's the authenticator. Here, I'm saying that it's not the best interest. Now,
the best evidence is the original, correct?
I mean the best evidence.
Best evidence means
the phone itself.
Right.
By not providing the best evidence in this case, it puts the defense at a disadvantage.
Okay, for the non-hearsay purpose of Ms. Pace saying, I saw this text, it was pin drop, and I decided to go to Tremont. How is not having the best evidence detrimental, unfairly prejudicial to your case?
Well, so that's more of a rule for, that's a relevance over the prejudicial 403 issue, which I would also contend with, but for the best evidence, it's being able to show, I received this message, here's the phone, it came from my daughter's phone, here's the proof of it.
You see, there's a distinction with what we just said. Said it came from my daughter's phone. The state's not going to say that. The state's going to say, I think it came from my daughter's phone. It came from a number listed as Jasmine's. And so that's why we went there.
But there is evidence to prove that comes from the phone, not a picture of the phone or a person's statement.
I do believe that the best evidence allows for duplicates to be used in place of the original, where the original perhaps isn't available. In this case, we're talking the difference between not a duplicate of a document, but a picture versus the actual phone. And I think for the purposes that the state is saying they're going to use it for, I don't think that the best evidence applies for this particular purpose. So that the defense motion for under the best evidence rule for this particular issue for the non-hearsay purpose be overruled.
I assume that would be the same ruling for the relevancy part of the motion.
Yes, it's relevant in the sense that it explains why the Paces went to Tremont at the time they did. That's obviously has a tendency to make the existence of a consequential fact more probable than without evidence. Next.
Two more, Your Honor.
Okay, anyone take up first?
Your Honor, we're going to take up the motion related to the photographs.
Got three more, by the way. Got the photographs of the decedent, video dressed in jail attire, and there's a demonstrative evidence one as well.
Yes, we'll do the demonstrative after. I believe that the demonstrative are included in the photograph that we referenced in the first motion, so it might be moved depending on the ruling.
So he wants to wear street clothes.
Content for everybody in the courtroom. We have let the victim's sister know. I think she's been staying here, but for everyone, this is the first time that this has been shown in this person's.
Well, we could do this if you, I need to see the photos.
Sure.
If you want to just submit them to me, no?
I'd like to do it today.
Okay. All right, we're about to show some very graphic material. This is something that can be very emotional. Relevant,
warning.
it's important to have the emotional aspect of this discussed before the jury sees it. So we're going to put some very graphic photos on the screen. Do we have to do the screen? Can you just not hand it to me?
I have, the state has printed out copies, Your Honor, and I also have it on a flash drive. I can go through the numbers of the issues.
Do you have hard copies of all the ones that, it might be easier, does the state have hard copies of the ones you intend to use?
Yes, Your Honor.
Okay, let's do that.
Your Honor, so what we have is the state has the state has
they're going to decide what images are allowed to come
they
in.
intend to use that have been provided from the medical examiner's office originally.
Some of the family members have not seen these
You'll see on the bottom of the
photos.
page, Your Honor, that there's numbers that start with 216 and that go through 254. Those are the numbers that correspond with the evidence that the state has provided to us. So for the ease of everyone involved, I'm going to reference those numbers starting with 216 and going forward.
Let's go make this Exhibit 3.
Thank you, Your Honor.
All right, gentlemen, we can do this a couple ways. I know you're objecting to it, but it might be easier for the state to say why they think it's relevant, or, you can argue that it's not relevant. They're going to just turn around and argue why it is. It might be easier, even at your motion, to have them explain the relevance.
Well, I think that there's a few things, Your Honor, that the court needs to consider, and there's specific pictures that I would like to direct the court to look to. Starting with 216 and going forward. These are x-rays, as the court can see, that contain images of misplaced within the suitcase. I would direct the court to image 220. That would be the fourth page in Exhibit 3.
Okay.
The court should note that in that picture, at the bottom, there is a signature for A. Smith. The defense's position would be, Your Honor, that this photograph is not a photograph that was actually taken by the medical examiner's office. We have combed through all of the pictures that were originally received from the medical examiner's office, and it's the defense's position that this is a combination of a number of different angles of the suitcase that has been combined to make one photo. You can see in that photograph that there's coloration that is different from the rest of the black and white photo. That would lead the eye to see certain objects, including the handcuffs and restraints in the suitcase. With that being said, this does play into the demonstrative evidence that we are objecting to coming in, but our position is that while there is no question that the state is going to allege that Ms. Pace is found in the suitcase, this evidence creates evidence that doesn't exist. There was no x-ray, there was no photograph of the suitcase as a whole. There was no photograph that was presented to us that shows the handcuffs in the position that they are. In fact, if the court actually examines that photograph carefully, you can see another set of metal that's not colored, and it's confusing for the jury. So our position is that 220 should be eliminated as it is unfairly prejudicial to Mr. Chen.
She was handcuffed in the suitcase?
220 is colored, that's not from the shoulder area? Or
When you go through, Your Honor, there are, on my copy, there are blue pictures, and that does not exist in any photos that have been actually provided by the defendant's office. You'll see at the bottom, this is the only photograph in the series of 216 through 220 that contained A. Smith. She is an employee of the medical examiner's office. She has created at least 2 demonstrative exhibits that have been provided to the defense. That coloration, that blue, is just to accent the metallic portions that don't exist in the other photos.
are you talking about the blue around the handcuff, or the blue, the little triangle-shaped blue kind of the bottom?
Both.
Bottom one. Okay. Well, is this a conglomeration of photos that were taken by the medical examiner's office?
You can see that they are obviously spliced together.
I do. I see that, but I mean...
We have not, I'm sure we could take the pictures that have been provided by the attorney's office and have something close to this, but we don't, there's no way for us to really authenticate where this photograph comes from. We weren't provided a copy of this actual photograph or anything similar to showing the entire body within the suitcase as a whole. And what we have are individual pieces sectioned off in multiple photos.
I mean, we'll say a badly decomposed body was found in the woods with the bones scattered, and there are photos of the bones in the places where they were found. But then the people found kind of put them together in the woods to kind of show that it was what they could, and that was a legitimate photo, not of what it was as when it was originally taken because the bones were scattered, but they, with the understanding and the explanation to the jury that these were put together to kind of give a more cohesive picture of what was found, you know, why wouldn't a similar explanation remove any danger of unfair prejudice in this particular photo?
We don't have body parts that are scattered in this. We have a body that is in one location. The MD's office was able to scan portions of this. They had the ability to take pictures of the entire suitcase and to scan the entire suitcase. They chose not to. What they did do was take pictures to build something that they had the ability to do it at the beginning. If in your situation, if the bones were built, the examiner or investigator would be taking those pictures and presenting it to the state and then to the defense. This is not something that we received until a month ago. And this is evidence that obviously has been pieced together for the purposes of a demonstrative issue. And our position is that it is prejudicial. Dr. Coxwell will have the ability to talk about the condition of the body. They'll have the ability to show this case in the suitcase, potentially, if the court will let those pictures come in. but he'll be able to talk about that. This evidence is truly created. It wasn't in existence. It was not made at the time of the discovery of this case, and it wasn't created at the time of the investigation. It has been created by someone within that office much later in time.
Well, again, I understand that the bones weren't scattered in this particular case, but it seems like this would come in through an expert, and experts typically deal through reams of data that seems spread out and unconnected, that they can put together a report or a diagram or something that kind of draws it all together. Does the fact that this photo or this conglomeration of photos, it's 220 here, be presented by an expert, how does that factor your argument?
Your Honor, I believe that Dr. Constable had the ability to testify about the condition that Ms. Pace was in and the steps that he took to find it. Our position with this specific photo is that there is no question that this photo does not exist and that it has been pieced together by multiple other photos. If you go through 216, 217, 218, 219, you'll see portions of these photos that likely created 220. Our position is that at this point, 220 is going to be cumulative of 216 through 219. But furthermore, it's going to be prejudicial because it is showing evidence that they have created truly for demonstrative purposes that they're trying to have issued as the proof for the jury to consider as what they see. Dr. Cogswell can testify to what he's seen, but this picture doesn't clearly show the jury what Dr. Cogswell saw. It does not show what the investigators captured when they were taking the many photographs they took. And there are hundreds of photographs, Your Honor. There's nothing that looks like this and what we've ever seen.
Mari, welcome to the gallery. Thank you so much.
Your Honor, 216, 217, 218, and 219 are X-ray images. They're not photographs. Let's start with that.
X-ray images?
I believe that Dr. Cogswell, during his testimony, if asked, would say that the X-ray machine would not be able to produce an image of the entirety of the suitcase in a single scan, if you will. The court is 100% correct. Image 220 is a demonstrative aid. It's a conglomeration of 216, 217, 218, and 219 to show them in correlation and context with each other. There would be nothing preventing the state during direct examination of Dr. Cogswell or an argument from putting photograph 216, 217, 218, 219 next to each other, piecing them together, and then highlighting for the jurors the various important metallic objects that are relevant to this case. Not the screws in the suitcase, not the handle, but the two sets of handcuffs, what are described as handcuffs and shackles. And then Your Honor mentioned the bluish object in the bottom right corner. That's the knife blade that we broke off of Jasmine Pace's body. That's clearly relevant. It assists the trier of fact in understanding the positioning of Miss Jasmine Pace because candidly, Judge, the proof will be that there's this suitcase. Your Honor will get to see it. The jury will likely get to see it. And an incredulous juror might say, how on earth does a human being fit into a suitcase like that? This photograph, 220, the composite X-ray is what I would call it, shows exactly how Miss Jasmine Pace was positioned inside the suitcase.
I think that's got to come in.
With a knife blade broke off in her chest. That, Your Honor, it's not unfairly prejudicial. Is it prejudicial? Of course, because it's evidence of guilt. It's evidence of a murder. The question is it unfairly prejudicial? And the defense has not met their burden.
I'm sorry, go ahead.
If I may briefly, 216, which is the first photo, that also shows that same knife tip. The state is asking the court to have the ability to enter pictures showing the same thing multiple times. Our position is 220 is a combination of 216, 217, 218, 219. If they want to stand up and highlight the stuff to the jury, that's one thing. But they've created a photograph that they intend to have the jury see as something that's brought from the medical examiner's office. That does not exist. If they want to, as Mr. Moyle has said, stand up and highlight the Dr. Cogswell and show the jury the pictures, if the court says that they commend, they have the ability to do that. 220 is created to give the jury the illusion that this is what the enemy's office saw, and they did not. They did not see bright blue metal pieces showing up on their x-ray, because 216, 217, 218, and 219 shows what the enemy's office saw. I know that, the fact that it's colored blue may sound trivial, but they are highlighting something, creating a picture that is brought to the jury's attention, asking for the jury to accept it as proof of what the enemy's office saw. And we're asking for the court to find that it is prejudicial. And there are other photographs that the court will likely allow for them to have in, including 216 through 219, that shows the exact same evidence.
I find that since this is coming in through an expert, that an expert certainly can put together images or data in this particular case. It doesn't seem like he's putting it together himself. He's just explaining the suitcase that he saw and how the x-ray machine was not able to take one x-ray, everything. I don't think that while it is prejudicial, the test is whether or not the danger of unfair prejudice substantially outweighs the probative value in this particular case, since it's coming from an expert who can explain that to the jury. I don't think that danger of unfair prejudice substantially outweighs the probative value in photograph 220 of Exhibit 3. So the defense motion to suppress photograph 220 be overruled.
Your Honor, in starting with 221, part of our motion, and going through 254, just so we're clear, part of our motion does request that the state's photograph be in black and white that display the victim. I won't go through each photograph for 221 through 254 and request that the court look at that photograph specifically and make that ruling, but we are asking that any photographs of Ms. Case be in black and white. For purposes of discoloration for blood, organs that are showing. And so the state may want to respond to that, and then we'll go through what we believe are the cumulative evidence.
Defense wants pictures of the body
Your
in
Honor,
black
the
and
case
white.
relied upon by the defense in this case, the proposition that color photographs should be excluded is extremely distinguishable. They rely on a Collins opinion, which is out of it's out of Hamilton County, Your Honor, quite a while back. In that case, the jury was shown color photographs of, quote, a bruised, bloodied, nude infant victim. And that's at 986 Southwest 2nd, 13, but specifically at page 21. You might be inclined, from hearing that description of the photograph provided for the jury's consideration in that case, that it was a traumatic cause of death. Maybe beating, stabbing, gunshot wound. Rather, the cause of death in that case was drowning. Which raises the question, what would be the purpose of showing a bruised, bloodied, nude infant? In fact, the medical examiner, when asked by the trial court to explain the photograph, said the pictures would show what the baby looked like, the size, but there's nothing really in the external exam of the infant that I think is confusing. Those are photographs of the infant in that case. In fact, the Collins opinion cites a different set of facts using an infant which showed color internal organs. The Court of Appeals in that case said that those were appropriate because it went directly to the heart of the question of what was the cause of death in that prior case, and in that prior opinion, the cause of death was massive internal hemorrhaging and bleeding. I would submit to the court that the color photographs in this case are extremely important. Dr. Cogswell will testify, I anticipate during the course of his direct examination, that he is able, based upon his examination of some of the wounds, to be able to opine as to the amount of blood in Miss Jasmine Pace's vasculature her circulatory system at the time that the stab, incise wounds, slashing wounds, so on and so forth occurred. Your Honor will look at some of the photographs, and let me just draw your attention to a couple of them by number specifically. If you look at photograph
And
241,
congratulations on 2 years.
241 shows
Courthouse looks great.
Jasmine Pace on the autopsy table with numerous marks. Your Honor will note that some of the wounds are more red, some of them are more yellow. There are close-ups of individual wounds. Specifically now, I would draw your attention more towards one of the last photographs, 253, which is a close-up of a stab wound on the torso of Miss Jasmine Pace. Your Honor will see how it's yellow in color. I anticipate that Dr. Cogswell will testify that in his expert opinion that's indicative of a lack of blood in the system of Miss Jasmine Pace at the time that that injury, that wound was inflicted on her person. That would indicate an approximate time or a sequence, if you will, of when that occurred during the 60 or so stab wounds inflicted on her. I think it's relevant and it should be allowed.
Wow.
Mr. Morrison, I don't see any of the photographs necessarily being duplicative. Closest was photographs 230 and 231.
Your Honor, I'm happy to walk you through what we believe are duplicative.
Okay.
We'll start with 223. Our position is that 223 and 225 are similar in nature and show the same view of this case, same location.
223.
223 and 225.
Okay, so 223, I see both cuffs connected by a chain, the handcuffs. And 225, I see one cuff. So it looks like they are showing two different things.
Our position is that the bag is just over the foot. That's shown in 223.
Well, is that a hand that's also shown in 223?
Yes.
It's not shown in 225?
Correct. Going forward,
Respectfully disagree with the duplicative nature of those two.
okay, 229 and 230, Your Honor.
I think you give me more credit than I deserve there, Renee. It's about a 50% chance. This is a gruesome case.
Shows an individual standing on a stool to take a photograph. 229 is taken at eye level.
Just a second, Mr. Morrison. Okay, I'm caught up to you now. You said so 229 and 230?
229 and 230, Your Honor.
This is in Tennessee.
And 229 looks like almost a horizontal picture.
It appears to be at eye level. 230 seems to be, you can see an individual's feet on some kind of stool next to it. They've taken a picture of above.
So, I mean, 229 does not show the victims left side, while 230 clearly shows the left side. I don't think those are the closest I thought were 230 and 231.
And our position is that 230 is less gruesome for the jury than 231 is. I agree with you that they are close in how they look, but 231 obviously has more blood visible than 230 does.
You know, I can see some distinctions between 230 and 231, but as far as the relevancy analysis that we're conducting now,
Yes, sir.
can you see that the bag is missing and the victim's head is turned from 230 is facing up, 231 is facing more horizontally?
Yes, Your Honor, and so the court's aware of this photograph, 231, I believe it is. Yes, 231 was not initially in our 12B2. However, if Your Honor will turn to 254, which is the other demonstrative exhibit that counsel was telling you about earlier, there is a superpositioning, if you will, of an autopsy photograph overlaid on top of a crime scene photograph. The outline of Jasmine Pace's body that Your Honor can see in 254 comes from 231. That's the only reason that it's relevant. I submit to the court that I would be inclined to agree to make this one black and white. Your Honor, it doesn't show the wounds to Miss Jasmine Pace, so I don't know that Dr. Coswell could opine as to the injuries shown on her body, but the outline of her and the position of her body specifically would be relevant for the purposes of comparison to that crime scene photograph.
Well, that's what I'd like to do before making a ruling on it. Just check with Dr. Cogswell, see if there is anything on this photograph. Unless you're representing me, know for a fact, he's not going to be able to do that.
I think that the only purpose of that photograph, Judge, was for the demonstrative exhibit, for showing the relative positioning of Miss Jasmine Pace as she would appear on that piece of carpet that Your Honor sees in 254.
So are there any major distinctions between 231 and 230? If I hear you correctly, 231 would definitely come in as a black and white.
Chase just started in LA. Thought I'd bring that in for
Would
you.
230 need to be admitted if 231 was admitted?
Your Honor, I would be agreeable to strike that photo.
Okay. All right, let 231, the defense motion to keep photo 231 out be sustained.
230?
I'm sorry. 231's coming in. 230, the objection be sustained.
Yes, Your Honor.
Your Honor, going forward, 235, as the court is called on.
Okay, thank you.
As the court can see in color, Mr. Cheryl Moyle didn't mention the Morris case. This picture does show Ms. Pace's eye slightly open. It shows her eyeball. There is no injury there at the eye. Our position is that the picture in color showing her eyeball could be considered gruesome for the jury. It doesn't show any relevant evidence within that photograph, with the exception of the cut below her nose. Our position is that this should be black and white and that it should be redacted to eliminate her open eye in the photograph.
Your Honor, the state would submit that we would be happy to redact Miss Jasmine Pace's eyes. There'd be a black bar placed across the photograph at the top to basically bisect 19. Where the colon is would be completely blacked out, so it would just show the tip of the nose down to the base of the chin.
Okay. Defense motion to suppress photograph 235 be granted in part in that the color be suppressed and the
Defense one
the photo be cropped
has to be black and white.
A black bar be placed across the victim's eyes.
Yes, Your Honor.
Your Honor, going forward to 237, our position is that 237, 240, and 241 contain injuries that are the same. 241 obviously has a greater portion in this case shown within it.
Chase's live
When
court was from
looking at
yesterday.
237, it is specifically injuries to her right shoulder and her facing part of her hand. Those same injuries are seen in 230.
Let's do this. Let's pause court and let's go full on the chase for a little bit. Is that all right?
Or, sorry. Also in 240, the same head injury is shown, as well as in 241.
Okay, we're going to pause court just a little bit and jump down right here and get some sound going. If we can. Where's my sound? Armed carjacking suspects is what we're hearing right now. Burbank, California. Let me see if I can get sound coming in. Should go into Black
A very
Magic.
dangerous person behind the wheel. Right now, though, we're blessed with light traffic today. It is definitely Friday light and also the end of a holiday. But right now, pushing 100 miles an hour, northbound on the 170, using all lanes of the freeway.
What's
and it
coming
looks
out the
like
back
we might
window?
be
Some
getting back
clothes?
off the freeway, and this is what it is.
Like
It's so
curtain up there?
dangerous about all of this is he's getting so close to other vehicles. Nobody knows that this car is coming up behind them at that high rate of speed, and then of course those blind turns and running red lights. It just compounds the whole dangerous situation.
What's the car? Can anyone tell me the car model? Stu is amazing. Stu's incredible.
Hang on. Yeah. Roscoe.
Came to a stop. He's looking in the air, looking up for helicopters. He's got like a shirt or something in the window of the back. Is that a flag? Please tell me that's not a flag.
Well, you know what? I'm with everybody else, and when you see something flapping out of the windows, and after those terrible things that were happening
New Orleans.
in New Orleans, you worry that possibly that is some sort of banner. It is not. It is not. I would venture to say that is some sort of window covering or something like one of those screens that they put over the windows maybe for a child, but the window is down and it is just kind of blowing around in the wind through that vehicle. That driver's still driving very aggressively. You can see some movement in the passenger seat. That's what we saw earlier on. We had a pretty clean shot of it. A female passenger, the male driver, and there might be somebody in that back seat. You got
like
a lot of tint down there, and you've got a lot of
window goes
and
up.
that thing kind of blocking the window. So we don't know, but I would venture to say it's probably, hopefully, just the two of them. But
Might
right
be a
now,
broken window with
making our
like a
way
bag
back
in
onto
there,
that
just like
170 freeway, high speeds out here, Sun
something to
Valley,
close.
and these are the calls that officers have to make. How do we protect the public? How do we keep our officers safe? It is a difficult call for sure.
It's
right
a
now,
Nissan
the
Altima
helicopter, the
or a
LAPD
Maxima?
helicopter is following
It's
it. But you
definitely
can
a
see
Nissan,
that
right?
car making those hard turns, weaving in and out of traffic, and again, topping out. You're getting into the triple digits out here. That's 100 miles an hour plus, and you know that vehicle. It's a newer car, but
can do
again,
that.
I don't think it was designed for handling at 100 miles an hour, especially when they're making those hard turns and last-second decision making. And with all that other traffic nearby,
hitting
you just
120.
don't want to see anybody hurt, even the people inside that vehicle.
Oh, and he just passed a cop. Just blew by this cop. The cop doesn't even light him up. Apparently he's on break.
Yep.
Yeah, he took the exit. Didn't he? Oh, no, he went straight. Cop just dropped his donut, spilled his coffee.
Yep.
Yeah, lately these chases in California have been more car commercial than they have been police pursuits. I think that back window was broken.
The moment we saw the vehicle was one of the things that I picked up right away. You could see that kind of flapping in the wind right there. I think that's actually attached, like they put it down and then they closed the door on it. I was afraid that it was some sort of banner or something. Thank goodness it is not. But also, look at this, 110 miles an hour, and we're doing those crazy weaving in and out of traffic. Going to get you a little bit of a wider shot because I just got to be careful what might happen down there if they are involved in some sort of high-speed crash. Passing these other vehicles, you can really get a feel with this wider shot how fast that car is going. Of course, we have the numbers up there on the screen for y'all, but it gives you a better feel when you're seeing this guy basically passing vehicles at freeway speeds. That is, it is pretty dangerous indeed. Right now, though, we're continuing. We're made our way southbound. This car has been making a lot of U-turns.
Wow.
That's the only consistent thing that I can say, just as an observer of what's been going on. Many U-turns. We were north on the 170. Now we're south on the 170. We were he was making U-turns even on surface streets when we were trying to catch up to him. He was on Moore Park for a little bit in the Valley Village area. Right now, though, it does definitely seem like we're staying on that 170 because he's
There's
far over.
no lights behind him that I'm aware of.
Onto the 101, and we might be heading through the Cahuenga Pass. But we've seen that car make these radical changes very quickly. So who really knows? Now we're getting into a little bit more traffic, and this always kind of worries me, especially when you start weaving in and out of these cars, and he has to start hitting the brakes because it does get kind of packed up. Look at this. This guy right here is probably like, hey, what are you doing, buddy? And that's also
like,
something
no, you
we
want to
don't
race.
want to see. Law enforcement doesn't want to see that either. Getting far over to the right and now coming all the way back. Oh, my goodness. This just gets more and more scary.
I would call that scarier and scarier.
Yeah.
Guy's moving. Yeah, I'm guessing that back window's is out. It's like broken out.
It
looks like it's down, and that was put in there to sort of protect it.
You know,
the sun or something.
all those kind of questions we might get answers to later on, but right now what I can tell you is the assignment desk gave us a call, said, hey, they're following a carjacking suspect, and they were on the 405 northbound near Sunset, so that was in the Brentwood area. Skyfox, sad to say, but happy to say, is not just like a pickup truck. We can't just jump in and start it up and run, so it took us a few minutes to get up into the air. By the time we did, he was actually already on the 101 freeway, and he got off. But the point of the matter is we don't really know. The pursuit started on the 405 freeway, but they were over by Mulholland by the time the actual pursuit started because they were waiting to get other cars behind them. They can't just have one car there to light it, like basically what they say, light them up, turn on the lights and sirens. And if it's a pursuit, this guy is
these are next level
all by
moves.
themselves.
This is GTA style driving if I've ever seen it.
There's a whole process that goes on. They got the helicopter over it. And so they had to get their ducks in a row. We were trying to get our helicopter in the air. But by the time we got there, he was already on the 101. So I don't really know if that was damage that was done to the car before, if this was...
it does look like he's got some scratches on the door or something.
Window was there when they stole the vehicle or took the vehicle by force. But again, we also know it has Florida plates on it. So there's a lot of questions here, and again, LAPD not letting this go. So they believe that driver is a dangerous
and
suspect.
taking the exit last second. Oh
and
my goodness!
I'm not sure if we're on Cahuenga or we're on Cahuenga right now, right? And look at that, just making that turn. He did slow it down in time, but we're making our way into the Hollywood area right now. Might get a little bit dicey because we have some buildings to deal with. Depends where he goes.
You got to stay right on top of him.
These high speeds, running those red lights, getting so close to all these other vehicles that just have no idea what's going on. Very, very dangerous. Look at that red light, kind of forced to make a turn there. Thank goodness he didn't get any closer to any of those cars.
Yeah, we're about to see Hollywood Squares, I think, or Hollywood Stars. The side of the road. There they are. There they are. They're the stars. You see them? He's looking for a parking garage, garage.
Northbound Cahuenga.
Round and around he goes.
Yeah.
We're probably going to start seeing police cars materialize here really quickly. He does not like sitting still. He's looking up at the sky, looking at the helicopters. Knows he's still being tracked.
Putting his hoodie on.
Because that'll help him. You can't see me now. I can't see you. In the bike lane. Again. passing in the bike lane on the right. This is nuts. Let's see if he comes out the other side. Does.
Very careless indeed. And, you know, that's one of the things. Look at this. Look at this. Oh, my gosh. That is so much traffic down there. And we just basically made another U-turn. We weren't on the freeway, or well, you haven't made a U-turn on the freeway, but our direction has totally changed. We were southbound, and now we're back northbound again, making our way back through the Cahuenga Pass, this time on the roads instead of the freeways. But, yes, definitely. When they get on the freeways, it doesn't mean that it's not dangerous. And it just means that there's, you know, less
just
of a
means
chance
when they crash, they're going
a
faster.
pedestrian or any other type of anything else, a bicyclist, anything that could get in the way. But there's still other cars out here, and he does get very, very close. And we have seen high-speed chases where they are by themselves. They make that hard turn. The car starts losing traction, and then, you know, poor driving, and then there's an accident, and people are injured.
So far, all the
we're
tires
always
appear to be good.
cognizant of that, and of course, law enforcement. This is the stuff that they deal with. These are the
I
things that they have to
I jumped to it
basically
probably
weigh out.
about
It's
2
like,
minutes after
how
I heard it
dangerous is
started.
this if we just let this
had to
go,
get it set up
if
for you.
we have the helicopter following it, you know.
We
they
love
are
Stu,
making
and
calls.
Stu does
They
a
are
great call on
saying
these.
that, you know, this is where he is to the officers on the ground. And that's why I always say, when this comes to an end, it will miraculously, officers will just kind of appear out of nowhere because they are listening. And believe me, law enforcement, they want to do their job, and their job is to keep the public safe and to take bad guys into custody. And this person right here, right now, he's acting very badly. So this is what it's all about. But the concern while this is happening is definitely safety.
What county is this happening in? Burbank. What county is that?
Hoodie. Yeah.
Do you think this would be the south part of the county? I don't know the LA County very well. Definitely
watching this car just kind of changing lanes out there. I was actually seriously just checking my phone, seeing if I can get any information, any kind of little tidbits that we might not have.
North?
Turns out just a lot of people saying, why didn't I tell them that there was a pursuit going on? I'm kind of busy. Anyways, we are watching this car, and again, LAPD in the air, and they are chasing them. And on the ground right now, they've opted out probably because of the high speeds and the dangerous maneuvers. They're going to keep their officers a little bit safer, but, you know, again, it's one of those handoffs because law enforcement, their lights and sirens are very helpful. I think there's are we off the one side? I thought we were actually right next to the North Hollywood LAPD. I thought that would have been a little ironic. Made that hard turn right there. I did see that's the first time I saw that rear wheel kind of slide out a little bit. So that was the first time I actually saw that car lose a little control. Now we're making our way clearly on Magnolia. This is going to get into a very busy area out here in the North Hollywood area. Lancashire is going to be up there, Riverside, all the big streets. And again, a lot of traffic out here, even though it's Friday. A lot of people got to get to where they need to be. And they don't know that this guy is just out here running lights and making these dangerous decisions. What did he pick? He did pick Lancashire. So now we're on Lincoln. You know, you asked that question about what these people are thinking. You know, I would venture to say that they really don't have a plan. I would venture to say that right now the only thing he's thinking is got to get away. but he doesn't even really know what he's getting away from because there is nobody right behind him. The helicopter is definitely above him, and they're making those calls. They're telling law enforcement on the ground where he is and what direction he's going. And especially in North Hollywood, they were eager. I wouldn't say eager, but they were advised that this was getting into their territory here earlier on. So they know that this is going on, and probably all the other divisions nearby know as well. Right now, though, the helicopter, LAPD, keeping an eye on it. We're going to be getting into the Burbank airspace. I feel Jeff bringing up the helicopter, and so I have a feeling that we're going to be staying up a little higher because possibly they have some flights coming in. Hopefully, we're going to be able to keep an eye on it, but you never know. It's always a fluid situation up here in Skyfox.
Trying to see if we got any police scanner on this as well. These guys drive so fast and get from one area to another so quickly that sort of have to
Keeping
jump.
an eye on it. We're going to be getting into the Burbank airspace. I feel Jeff bringing up the helicopter, and so I have a feeling that we're going to be staying up a little higher because possibly they have some flights coming in. Hopefully we're going to be able to keep an eye on it, but you never know. It's always a fluid situation up here in Skyfox.
87 miles per hour on a surface street on
Now they're bringing
Lancashire
us on
right
the-
there in North Hollywood, and we're looking
the
at this
anchor feed
driver
as well.
going on the freeway, off the freeway, back on the freeway. So really unclear where they're going to go. Obviously, we don't know. And for one moment, I think from your vantage point, Stu, we did see the sign of a passenger in the car. As we've mentioned, there could be possibly a woman, a female passenger in the passenger side seat. And so we don't know the state. But clearly the car looks like it's a little damaged, right, from the side and the back. And then you said that the rear wheel seems a little wobbly at this point.
Yeah, you definitely some damage on that vehicle, and you know, clear.
Whoa!
Gosh, that is. Anyways, it is definitely damage on the vehicle. That is not a clean Nissan. I can tell you that. That has been. It is.
Hang on, your name says Tickled Pink Music, but you say no music, please.
Did you? Oh my goodness! And you know, and that's the thing too. This is a little.
We
bit
use this
off in
music
the
on the bus
distance, but
chase.
believe me, that was a
It's
pretty
almost
close
over.
call. I venture to say that driver in that white vehicle, believe me, they flinched, and I don't blame them. And this is what the problem is. This is what all the issues are with the pursuits. It is so dangerous for the folks on the ground, and of course, law enforcement. I've said it in the past. I'll say it again. They actually are concerned about the driver and in this case the passenger safety as well. And that's the reason why we have all these policies in place where they say, all right, we're not going to chase them, or okay, we are going to chase them, or we're just going to use the helicopter. And in some cases, they just let them go. And I say it with a little disdain, but also in that same breath, it is the safer thing to do a lot of times. And that is what it's all about, is, you know, how...
He's going to jump. He's going to jump. He's going to bail.
Somewhere in here. It looks like we're doing some...
Oh, 3-point turn.
Maybe he got to put some more dents in the car. That's what it was. You just
dumpster.
wanted to put a couple more dents in the car there.
It's a rolling dumpster.
Making the turn, yep. She seems to be in some kind of Snuggie.
There is a
definitely
passenger.
dressed for the weather. I don't know if the Star, they were probably listening to
Does
the
she
Star
have
a
running
little bit
shoes on,
earlier
though?
this morning.
That's the
but
question.
Both of them, you know, wearing layered stuff. And again, even that, he could have got, you know, could have bumped that car's the back of that car, making another sharp turn right there.
Backed into that dumpster right there to make that turn.
He doesn't know where he's going.
It's just crazy.
Oh.
How
Look at where he's going into. What is this? A
parking lot.
Parking lot.
No, this is it's a parking lot for an apartment building. I have a feeling they're going to park that vehicle if they haven't already and jump out. We're gonna move Skyfox as quick as we can around over there. Jeff making those moves, but I have a feeling.
Go, Jeff.
They're
Go.
running. I'm going to keep it a little bit wider just in case. But I would venture to say they might actually have known. Up there they are. There they are. That's what I thought they were going to do. She is definitely checking on whatever's in that back seat. Hopefully it is not. It is other people.
Oh my goodness.
Oh my goodness.
But right now they seem unfazed. They don't. There's nobody following them, so they're just casually walking out. They're kind of looking around, but there's no black and whites behind them, so there they go.
Huh.
There they go. And I'm not sure where the guy went. I'm gonna turn up my
Stu, don't die on us.
Sorry about
Stu.
that. Still got that same cold that everybody has. I'm turning up the scanner just a little bit to see if LAPD is making some calls right now, but I definitely can tell you we're at the corner. You see it. We're at the Runnymede in Lancashire in the apartment building. I was
There's they are.
watching her more than
Black and
I
white,
was
it's top
watching
right.
the driver. LAPD more concerned about the driver, I'm sure.
They're
but
putting a perimeter
right
up.
now, that vehicle parked. And everybody that was in that
There's
car
another one.
now out of
And
it
another
and
one.
Walking around LAPD. There they go. I have a feeling. Oh, the driver's being taken into custody there off of Lancashire. We'll move once again, and then she went back for something.
Oh my!
She has no idea.
You can't.
She's gonna run around the corner and see the cops.
It's hard to. Interesting. I don't know what the word is to say.
There's someone running in the back. Oh, those are officers right there trying to go find her.
But just
There
so
she is.
nonchalantly, just like, oh, I forgot something. Let me go check on that.
After a high-speed chase.
This is bizarre.
Yeah, it's very bizarre. And you know what? Nobody.
Driver gets away.
Oh my goodness! I feel so bad for those officers. Oh my gosh! Wow. Oh, I feel bad for them. It's one of those ones.
Officers in the middle of the road chasing him, gaining ground.
Okay.
I'm sorry, but the driver is not a runner. He's not a runner. He's better at. Civilian steps in for the win.
Who knows?
Something you don't want to do. Get involved.
Officer down. Officer. Oh, he tripped there.
They went into.
I saw his hoodie run into the in and out service.
Yeah, he's gonna get full service in just a minute.
Blocked in there. Hopefully, this doesn't turn into anything else except for them taking him into custody. But
civilian
kind of
pulling in
ironic
front.
name of
Oh
the
my
store where
goodness.
You run into to bring the pursuit to an end. But my goodness.
What happened
Accident
to
lawyer?
the female passenger? Do we
Good
see her
advertisement
down
there.
below?
Great.
I can go back there in just a second. I just want to see and make sure that nothing interacts inside of here. And also kind of taking a peek. Maybe there is a back door. It is an alley, so you kind of wonder maybe that this person was able to get out the back. You can see other officers. Basically, they missed the turn. You guys missed the turn, buddy. You missed the turn. But yeah, we're going to keep an eye on it. There he is.
got
He's
him.
in custody. Okay. He's in custody.
Hood up.
Let's see if officers are still in that apartment building. That was right over here. I did just hear, I think somebody might have been asking also if the female's in custody.
Yes.
But
on the scanners,
but they are
probably,
definitely want to talk to her, and I have a feeling they know exactly where she's at.
So you did see the driver being taken into custody initially?
Yeah, he's
yes, definitely.
Okay, so we have two.
Let's see.
That's the driver right there in the gray hoodie.
Making the walk of shame all the way back.
There he is.
And then there was a female passenger in the front seat. And
Officer's
then a
limping
passenger in
just
the
a little bit.
back
I think he
seat.
got tripped up on a curb.
Just
definitely
strolled out of the car.
looked at. Yep, looked like a younger person in the back seat. I'm not saying a child by any means, but definitely seemed to be a little bit younger than the crowd. And then I also heard him saying something about the south side, so maybe they took him into custody here. But wow, you know what? We're just glad that nobody got hurt in this at all. But LAPD, it's a tough job. It is a tough job, and these guys do an amazing job keeping everybody safe and taking bad guys into custody.
Well, absolutely. Very lucky that innocent people did not get hurt, because that was just a wild, wild chase with a careless driver there. All right, Stu. Well, we're going to take a break, and we'll be right back.
They're going to be right back.
Okay, this is the female passenger and the passenger in the back seat. So just a close-up shot of them. We'll keep an eye and see where they ended up. We'll be right back.
Just the shoes, distinctive shoes. That is awesome. All right, thanks, Stu. Thanks for the little pursuit there. It broke up a little bit of the monotony of what we were doing today, which is the preliminaries, the groundwork before the case begins in the Tennessee versus Chen case. It's a murder case. Stabby times 60, and handcuffs and shackles were involved, and as well as a suitcase. It's a rough one that way. Oh man, I think there were child safety locks on the back door. She had to go back and let him out. Be like, hey, I can't get out. Open my door. The window was down. He could have just reached around and grabbed that, but we're all awake now, says Melissa. We are. Are you done for the day? No, we've got to go back to court here. We've got a little bit more to follow. If you listen carefully, you can hear the judge.
We are in a position that those are cumulative errors.
Looks like the ruler is placed at different places for those 3 photographs. I mean, what do you think, General? That's something weird?
Your Honor, I would submit that they are relevant. Your Honor, 237 shows what's described on page 2 of the autopsy report of, quite honestly, a litany of injuries, starting with the right side of the head and neck, numerous stab and incise wounds. It then describes with particularity upper forehead, near the hairline. It penetrates to bone, so on and so forth. So I believe that 237 is relevant. I would submit to the court that it's not unfairly prejudicial. The photograph number 240 shows specifically an injury described to the left side of the head has a wound, the left side posterior neck has an oblique to 1/8-inch injury. That actually is not the same cut in number 240 that Your Honor can see across the center part of the photograph in 237. 240 is actually on the back of the head versus 240 being what I would describe as being near slightly above the ear on the temple. So 240 actually shows a different wound, which is not pictured at all in 237.
Our argument then would be that 241 and 237 do show the exact same wounds, with the exception that 241 shows a greater portion of Ms. Pace's torso and back. With that being said, 237 is just a closer shot to the head wounds, which are all shown within 241.
Again, it looks like there's a ruler that's placed in 2 separate places in 237, 241. 241, the ruler is placed near the victim's torso. On 237, it's placed on her neck.
And then while the ruler has moved,
Trial
all the
is
injuries
going to
shown
be in
241
Tennessee.
are the injuries that are contained within 237.
In Nashville. And the jury's going to be sequestered throughout the trial.
One difference it looks like in 241, the victim's left wrist kind of obscuring her face, her nose and mouth, while in 237 it's not. I don't know if that's relevant. Just looking for differences. You can tell me if that's relevant or not.
Your Honor, I submit that 237 is extremely relevant and highly probative of the injuries that I described on page 2 of the autopsy report. Number 241 shows a general overview, but most importantly, it begins to describe a series of injuries below the neck, Your Honor. So it provides context for the injuries below the neck. Additionally, Your Honor, you will note that since it's pulled out quite a bit, you no longer can see the coloration of the wounds that are extremely clear in 237, specifically the subcutaneous tissues above her right ear, as well as the damage down the ear canal in number 237. So I submit that they are different and that they're for different purposes.
Morrison, it looks like the ruler is covering a wound in 237. I think your argument is that 241 covers them all in. It's like displays all of them.
It does.
I think that the photographs fall very similar. They're not. There is a couple of distinctions as far as where the ruler is placed to give the jury a better idea, a less speculative idea of how large these wounds are. again, if 241 were to be the only photograph that was entered, it would not show the bottom part of the victim's face with her hair underneath her. Looks like there's some coloring on her cheek as well. So this was a more close call, but I'm going to find that they are sufficiently distinct enough for an expert to point out the differences, which would be helpful to the jury. So the defense's motion to suppress 237 go overruled.
And are going forward to 238 and 238 and 239. You can see that that is 239 is shows an individual pulling, as this case is Chen up, so that there's a different angle of the injury that's shown in 238.
Looks like the difference to me, 238 shows an entrance and an exit. Perhaps, I don't know, 239 looks like it shows, if I'm looking at that correctly, a complete gap from one side of her neck to the other. General?
Yes, Your Honor, that is what it shows. Your Honor, so the court is aware, this is one of the specifically enumerated anatomical findings of Dr. Cogswell on the medical examiner's report on page 1, what is described as the major damage to the larynx, right jugular vein. So we would submit that that is extremely relevant. It shows a complete perforation through the trachea of Miss Jasmine Pace, as evidenced by 239.
These photos are clearly distinct, and obviously the distinctions for these two have what seems to be obvious relevance. The 238 shows the entrance and what looks to be an exit wound, while 239 shows the some part of the internal aspects of the physiology of the victim. So the defense motion to suppress either 230 or 239 should be overruled.
And with that, the court has even indicated that you can see part of the internal organs of this case through that photograph. Would the court be denying our request to have this photograph in black and white?
I think that the general's argument earlier about discoloration certainly apply to this photograph in the sense that you can see both red and yellow. And if it pertains to the argument that was made earlier about when the blood flow actually stopped, it seems like this photograph would also be part of that same argument. I'm missing some generals at the same argument we made earlier.
Yes, Your Honor.
Okay. So let the defense motion to have photograph 238, 239 be in black and white also be overruled.
Your Honor, and then there's another set of 3 photographs, and they are noted as 248, 249, and 251. While this does show different angles in 248 than it does in 249 and 251, all 3 of these photographs are of the same main wound that's shown initially in 248. 249 shows that the wrist is slightly turned, and it shows a different angle. And 251 does show the underside with the palm up of the same hand that's originally shown in 248. So our position is that they are duplicative, those photographs.
Duplicative. Shows the same thing as other pictures. The state wants to have all these pictures in. They're very impactful.
251 is of the palm being up. 249 is of the palm being down. You see there are 4 splashes there. 248 only shows the main one that is shown in 249 and 251.
And these are very distinct. 249 and 251 are separate sides, same extremity. 248, it looks like is one of the wounds shown in 249, but at a different angle. Again, as long as the general understand it, the ME is going to discuss how these are significant as far as time of death and things like related to the damage that each one of these blows inflicted. Is that correct?
That's correct, but 248 is actually the only photograph that we have of an injury described on page 3 of the autopsy report, a superficial wound in close proximity to that large cut. Furthermore, the autopsy report documents the wounds to both the top and bottom side of Miss Jasmine Case's left hand. Your Honor can see that while 248 does show kind of a side-on view, it does not show the damage or the number of wounds indicated on 249 to the top of her left hand, nor does it show in 251 the injuries to the underside of her left palm. So we would submit that they are all relevant and also the color is necessary again for the same argument that's been proffered by the state. I anticipate Dr. Cosgrove will be able to opine as to the relative timing order, I guess, whatever the term the court would like to use.
I think these photographs are distinct enough from each other to show, while it's the same area, to show different relevant aspects of the wounds that were inflicted, but the defense motion to suppress some of the photographs of 248, 249, 251 be overruled.
Your Honor, related to, and I'm sorry to go backwards, but 243, 244, and 245 do contain angles that would show Jasmine Pace's chest. The state has provided us with copies in which they've been redacted. Our position is that 244 and 245 are duplicative of one another. They're just from a different angle. Both of those photographs show rough markings on Mrs. Pace's arm. You're able to see the same. You're able to see the same coloration in 244 that is shown in 245 for the rust as well as the marking as well as the same tattoo.
Looks like 244 is a larger picture than 245. I'm trying to see if there is anything different in 245 that's not captured in 244. Gentlemen.
Your Honor, 243 shows the right chest with a 3 1/2 by 1 inch contusion. It's that large purplish area right below the black square, the redacted portion. Photograph 244.
You can just tell me that 243 is definitely distinct. You can just distinguish the relevance between 244 and 245.
Yes, Your Honor. 245 shows a right elbow with a 1/4 inch superficial incised wound. As well as, Your Honor, if you look, you take notice of the handcuff imprint with custom on the right forearm. It does not appear in the photograph 244.
Ms. Morrison, I do see that now. It looks like 244 and 245 are distinct for that reason, and that 245 does show some type of ligature or something, I guess at the cuff mark, perhaps, below, or between, I should say, the tattoo and the marks left from the chain, and that's not in 244. Defense motion to suppress some of the photos of 243, 244, and 245 overruled.
And then finally, going forward to 254, This does tie into the last remaining motion related to demonstrative evidence. Within the ME's report, there's nothing that indicates that Ms. Pace was handcuffed while on the carpet. This is evidence that has, again, contains the signature of A. Smith that is employed with the medical examiner's office. The picture that the court has allowed in, which was indicated as 241, sorry, I believe it's 231. Yes, 231 has been flipped and placed into this photograph. This is carpet that was removed from Mr. Chen's home, and that a photo of Ms. Pace has been placed on the carpet once it's been turned upside down. Our position is that this is overly prejudicial. There is not testimony to our knowledge. There's no reports that show that Mr. Coxwell's testimony is going to be that she was cuffed while stabbed. This does present to the jury the idea that that's exactly what happened. It's misleading and it's unfairly prejudicial to the jury.
Your Honor, demonstrative exhibits are well recognized. Dr. Cogswell is a forensic pathologist. He's furthermore the medical examiner for Hamilton County. I've drawn the court's attention and counsel to page 2 of the autopsy report, and I'll read it here shortly. Her right ankle is handcuffed, and this is in the evidence of injury general portion, about halfway through that paragraph. Her right ankle is handcuffed to her right wrist, and her left ankle shackled to her right arm at the elbow. The doctor goes on to continue with another paragraph. A total of 60 stab and incised wounds are present on the body, primarily involving the right side of the head, neck, upper back, and right arms. The injury locations are consistent with the decedent's fetal positioning as found.
She was
Your Honor,
handcuffed
as a forensic pathologist, as
in that position and then
as
stabbed.
the Hamilton County medical examiner, Your Honor, if you take a look at image 254, Your Honor will notice along both the left-hand side of that photograph, there's a yellow and black marker indicating inches. Along the bottom is a ruler also indicating inches. I think Dr. Cogswell, within his expert opinion, can make anatomical observations about the height and weight of Ms. Jasmine Pace, the position of her body as found, and make comparisons to other items of evidence. In fact, Your Honor, experts are permitted under our law specifically to opine as to items that are submitted to them during the course of the trial. State could put the picture, the crime scene picture, up on the screen and ask Dr. Cogswell if that means anything to him, and he could opine within his expert opinion, yes, I believe that to be the outline of a human body. As you can see right here, there's this sort of an injury, that blood would flow in this general direction. I believe that's completely within the realm of his expertise as both a forensic pathologist and a medical examiner, and therefore he would say, in my opinion, that was the position of Ms. Jasmine Pace at the time that she died.
Ms. Morrison does seem like, again, this is coming in through an expert. They regularly make diagrams, maps, compilations of data. So this seems that it would fall in the realm of an expert's ability to testify, giving thoughts. I mean, it seems to fit with what we talked about earlier with the conglomeration of the suitcase photos.
Our position is it doesn't appear to be something that has been created by Dr. Cogswell. I mean, as indicated in the photo of 254, there's an individual that has the name of A. Smith, whose signature is there. This hasn't been provided to us through any report of Dr. Cogswell, but has came as demonstrative evidence from the state that they claim to put in. Our position that we have noted within the demonstrative, which I'm crossing over to the last motion, but I do believe that they're related. The photo that's being asked to be considered for the court shows a ruler. It shows a scale. There's nothing that we are able to do at this point to indicate or to confirm that these photos are in fact to scale. We have a photograph that's been imposed to a carpet that has a ruler, and the dimensions are showing that one photo is potentially at 282% while another one's at 560% if you were to go off what Mrs. Pace's actual size is. When you're looking at that, there's no question that it can be confusing to the jury, especially when one photograph has had to be shrunken almost half of the size of the other one to make it work. Also, if you look at the photograph where Jasmine is there on top of the carpet, you would have to be looking at her because the right side's up in this photograph. As General Moyle just indicated from Dr. Cogswell's report, the injuries are from the right. So that would mean that she would need to be laying on the right side for the blood to be there. It just doesn't make sense. It's confusing. And I believe that the state has created a demonstrative evidence, or a photograph to use as demonstrative evidence that goes against what the report of Dr. Cogswell says, what his testimony would do, and it is only to inflame the jury. For them to see Ms. Pace laying on a blood-stained piece of carpet, and for them to be asked to believe that she was stabbed while shackled, which is not in the report. There is statements of fetal position, but there's nothing that indicates that she was shackled at the time of the assault. It is creating ideas for the jury that are not in existence in evidence.
As far as her being stabbed while being shackled, that I didn't draw that conclusion of looking at this. There are lots of ways it could have happened. She could have been stabbed.
The photo does show the cuffs at her feet.
Sorry?
The photo does show the cuffs at her feet, the shackles.
And I can see that from this photo that has been superimposed, it's obviously one where she's been shackled, but superimposing it over this blood pattern, that doesn't necessarily mean that's where she was stabbed. It might have been where she was brought after she was stabbed. As far as the right side versus left side, the wounds may be on the opposite side, but the blood would obviously run down to the carpet. So I don't know, I don't think there's any conclusion that can be drawn from this photograph at all, much less an unfair one, other than that her body happens to match that particular pattern of blood. The way the blood got there, when it got there, when she was shackled, that's all speculative. I don't think this photograph necessarily invokes any unfair speculation on the part of the jury. Let me ask you this, I think you said it earlier, but the A. Smith individual, is that an employee of the medical examiner's office?
Yes, Your Honor.
Okay.
I think she's considered the forensic assistant.
She's not on the witness list.
Well, she's an employee of the medical examiner staff. I mean, this is a demonstrative exhibit coming from the office where the expert that's going to testify works. So I don't see any substantial danger of unfair prejudice outweighing the probative value on this one. The jury would see it, in a PowerPoint closing, or even while the expert's testifying anyway. This was created by the expert's office, so I don't think it creates the danger of any unfair prejudice, at least not to the degree that it substantially outweighs the probative values of the defense motion to suppress photograph 254 be overruled.
Your Honor, and to just follow up on that, related to General Copper, Dr. Cogswell being an expert, we haven't received anything that shows that Ms. Smith does have any expertise to create such images that has been created, and that is the basis for our motion in the demonstrative, dealing with demonstrative exhibits, why they should be suppressed.
Well, Dr. Cogswell can certainly explain the fact that there are rulers in some tape that marks off distance. I think that's something that Dr. Cogswell can explain. don't think you need to be an expert to superimpose something. You just need to be an expert to explain its relevance, which I think Dr. Cockrell is going to do. So I don't think that creates another basis to suppress this photograph. So again, but the defense motion to suppress photograph 254 be overruled. Any more from these photographs, by the way, we can talk about?
No, Your Honor.
No defense.
Not mistaken.
Your Honor, just, so we have the ruling as to the photographs in general, but our question for the court related to the demonstrative evidence of 254 is if Dr. Coxwell did not create it, and we don't have any reports from him related to it, how is it exactly that he's going to be able
I'm hearing that the sentencing for the Pike murders is a little crazy.
Whether his assistant created it, whether his computer program created it, whether
let me cut this out for a second. I'm hearing that the Pike sentencing is a little bit crazy, and I might jump in just to see what happened just a little while ago. So let's jump over there just for a second and see what's happening. This is a few minutes ago.
For gone to trial. There's the explanation. Court costs, processing, booking, paid to state medical expenses, have to pay the legal obligation. There's no victim restitution because they have civil remedies available. So you can go ahead and be excused. They're going to register you under both those registries.
Is it before this, Amber?
Take a break, so we're going to go off the record. Thank you to the lawyers.
I think it was before this. It was before that. Let me find the spot where it was. Was it the gentleman with the white hair? Let's back up a little bit.
Yes, Your Honor. Did you hear them also, Mr. White? Did you hear the statements?
Yes.
Do you have any issues or corrections you wish with regard to the plea proceeding, Mr. McVeigh?
No, Your Honor.
Think of anything on this case, Ms. Canepa?
No, Your Honor.
So what we'll do then is allow the defense attorneys to make their statements. You get a chance to make your statement. Choose to do so, Mr. Wagner. So that's how we'll proceed. Understand?
I believe if I got this case right, this is the family that basically went and annihilated another family so they could get
loudly enough,
a
Mr.
child
Wagner, I may not be doing that.
conceived by two members, a member of each of these families.
Okay. I will try to speak louder and slower.
It was wild.
But anytime you
Everyone was
don't
involved.
understand, do exactly
Wagner's,
what you did. Make it known.
Okay.
You can't miss this because of a hearing problem. Understand?
Yes, sir.
So thank you. Go ahead.
Thank you. We'll do our best to make sure that he has full hearing and understanding, clarify anything that we may have some questions about. Your Honor, thank you for this time to speak on behalf of Mr. Wagner with regard to the sentence. I will keep my remarks relatively brief. I say relatively because the nature of this case calls for certain remarks to be made. But nevertheless, we have filed a sentencing memorandum on his behalf. This court is well aware of all of the proceedings with this case, the joint recommendation of sentence, the plea agreement that had been entered into, as well as a defense agreement that was entered into, as Mr. Wagner has complied with up to this date and would continue to comply with. Again, my remarks will be brief, not because this is not a serious case. No one could, in their right mind, argue or anyone else that this case is not serious. And you spoke in terms of references to a master and that sort of thing. There are very few cases in the state of Ohio that are of this severity. Certainly none that I have handled, although I have handled some multiple homicides involved. But out of respect for the family, the parties, and all involved here, given that this has been litigated, it's been tried in one instance at least over the last 6 years, there's very little that I can say that someone hasn't Administration's recommendation of sentence with the state of Ohio in this regard. That agreed joint recommendation of sentence was 8 consecutive sentences of life without parole. Wow. The aggravated murders involved herein. And it was also indicated that we would stipulate, agreed to waive and stipulate maximum consecutive sentences of both warranted, necessary, and appropriate in this case. I believe that probably would address the questions of merger. We know that Mr. Wagner knows that it's up to the court when it comes to sentencing. What I would indicate to the court is that he is fully aware that in entering the pleas that he did, he would be subject to a maximum possible sentence of 8 times life without parole, an additional 160 years if sentences were imposed to the maximum consecutive, and that 78 of the 160 additional years would be mandatory sentences. Again, the parties stipulated, or that we stipulated, Mr. Wagner stipulated to the necessity that consecutive sentence, maximum consecutive sentences were warranted, necessary, and appropriate in this case in order to effect the agreement of the state of Ohio. Again, Mr. Wagner understood what his maximum sentence could be. He understands and understood then that it would be up to the court as to what sentencing would be, but certainly he entered his pleas knowingly, intelligently, and voluntarily, knowing that he was subject to the maximum sentences as already addressed of 8 times life without parole plus an additional 160 years.
Okay, we're going to go back and try to hear the beginning, the victim impact statements. If you give me just a minute here. Let's, they apparently got quite heated. Let's see if this is where it started. Let's jump ahead just a bit. This was the mom, right? This particular court case was awful. Awful video, awful audio, and it was just staring at the wall the whole time. It took forever. We didn't watch this. Waiting for the judge. We're going to skip this part. Want to get to the victim impact statements as the camera just wanders around the room. Still looking at the ceiling. Nicely done. Check the settings. Yep, the camera's working. Good job. Okay, there we go. People coming in. There's defense, bailiffs. Now I get a spam call? Hello?
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 Good morning. This is Kristen. I'm calling to let you know that this enrollment period, you could enjoy fantastic free benefits like food cards, flex cards, free meds,
food?
and up to $250 cash back with your Medicare plan. So do you have Medicare Part A and B?
What kind of food cards?
I just want to confirm whether you have both Part A and B of Medicare.
I want to confirm what kind of food cards you have. I'm all about the food.
So there are several new benefits in the annual enrollment 2025 from the leading insurance providers right in front of me, including free medication, vision, dental, hearing, food cards, and even cash back up to $250. So can you confirm if you have Part A and B of Medicare?
Tell me more about the food cards.
I hear you. We'll revisit this conversation at a time that suits you better.
Okay, sorry. I guess I can't find out about the food cards. So people are still coming in, so. Skip ahead until we get to, yep, we have cuffs, we have a radiator, we have a chair. All the important essential parts are here. Hair is here. We can now start the case. Good artistic shots here. Waiting for the judge.
Indivisible, with liberty and justice for all.
There we go. Pledge of Allegiance.
Be seated. Good morning.
Just got the last of it.
Good seeing you.
This footage taken from a Predator
three cases
drone.
On the court's docket today. 2018 CR 158, State of Ohio versus Rita Newcomb. 2018 CR 156, State of Ohio versus Angela Wagner. 2018 CR 154, State of Ohio versus Edward Jake Wagner. The cases are set for sentencing today. Mr. O'Brien, I'm sorry, he's not here. Ms. Knepp is here on behalf of, there he is. Mr. O'Brien, how are you?
Hey, Mr. O'Brien.
I'm not appointed on that case. It's scheduled for sentencing,
okay.
So I will not participate.
You're welcome to sit wherever you like. Appreciate your experience. Ms. Knepp is here on behalf of the state. I'll introduce the defense lawyers as the cases are called forward. I asked everybody to say the Pledge of Allegiance this morning as an acknowledgement that this is a government function. Sentencing in criminal cases is exactly that. There's a lot of different perspectives in the courtroom. There's a lot of different interests here. But the one common bond that we have in this function is that it's a government activity. So if you can understand my responsibility is to come at it from that perspective, you're all entitled to have your own viewpoint. But that was the start of it. Sentencings in most cases have a certain amount of emotion. The more egregious the case, the more difficult the facts, often the higher the emotions. In high-profile cases, there's expected public discussion. It's not unusual for people to later on go express their First Amendment opportunities and rights to communicate with each other. Often that means, did the judge get it right? Did he listen to the defendant's side or the victim's side or the state's side or whatever side they advocate for? And that's all appropriate for people to be able to have their perspective as a part of our First Amendment privilege. However, the right to public discourse really doesn't exist in this room outside the rules. And the rules are that decorum matters. So everybody's been well behaved, and I expect that to continue all the way through. As I explain the process to you, I'll expect you to follow the process.
Good luck,
it's an open courtroom. The Ohio Open Courts Amendment to the Constitution allows
got to skip ahead.
Or whatever access. That's all appropriate. I get that. But the right to public discourse has its limits, so the privilege of being here is only as good as you are. If somebody wants to express their First Amendment rights during the course of the proceeding, I'll shut that down really quickly, because in this setting with emotions on all sides of the case, there won't be any spirited debate. That can all happen out on the street, but it's not going to happen in the room. With regard to some preliminary matters, I want to call attention to the fact that the court staff has done a fine job pointing me in the right direction, getting me to the right places, helping with scheduling. So I guess I want to acknowledge the Pike County Common Pleas Court staff, and then carry that a step further is to acknowledge the Pike County Sheriff's Department and the STAR transport team with regards to logistics and public safety. So to the extent that the sheriff provides a lot of resources, the court wants to acknowledge that also. The process today will be as follows. There's some legal matters to take care of with regard to Angela's case and Jake's case. Best way to introduce them that way. So I'll take care of those preliminary matters after the sentencing involving Rita Newcomb, because that's a relatively straightforward case. But with regard to the legal matters, what I'll do then is this. First, have the state make a recommendation on all three cases, have the victim's statement on all three cases, sentence Ms. Newcomb after hearing from her lawyer and her. Then I'll switch to Angela Wagner's case, work on merger, then I'll work on Jake Wagner's case with regard to merger and sentencing. So we're going to do one state recommendation, we're going to do one victim statement that applies to all of them, and then we're going to individually sentence 3 people. There's a lawyer here on behalf of the victims, Ms. Gall or Golly?
Yes, Your Honor.
Thank you.
Gall on behalf of the victims.
Gall, G-A-L-L-E, but Gall. Thank you for being here. The only unresolved issue is whether or not the victim representative, who you identified as TR, would like that person's identity or their statement to be televised. They have the right to confidentiality, so I just need to know for the media how you want to do that.
Your Honor, there are actually going to be 4 victims that would like to address the court and for the Constitution and their rights, because they do have the right to be heard at any public proceeding involving sentencing, especially. And I can get citations for that if you'd like, but TR is actually not going to speak. It is going to be 4 others. I believe Angie Canepa is reading 2 of those statements on behalf of the victims. And then there's a mother that would like to speak and a niece that would like to speak.
What?
So let's have an understanding. I just wanted to know first whether they wanted to be seen or not. So can you answer that for me?
They have no objection to being recorded.
Okay, thank you. Thank you. Now, the second question would be why at the 12th hour you tell me that you have other victims and you entered appearances for people you haven't entered appearances on. I'm going to give you what you want. To a point. To a point. Because the obligation to come in and represent people doesn't mean to come in and change the script. So there's 10 minutes allocated to whatever 4 people are going to speak. I just need to have an identity for the record. If you want to use initials and give the court reporter their names, that'd be fine. What? But like you entering an appearance on behalf of somebody that doesn't want to speak really doesn't work for me. So don't answer that. Just understand that I'll give your 4 people 10 minutes, and I want their identity, and you want to give me initials, that's fine. Just write down their name so I have it for the record. Understand? Do you understand? Do you understand?
I need to make a clear record for purposes.
So you can make the record after we're done. Now, do you understand what I just said?
Yes, and I'm
Thank you. Okay, then sit down.
I object.
Wow.
This is the victim advocate representative?
With regard to Ms. Newcomb's case, it's Mr. Gerlach, right?
Yes, that's correct.
Nice to meet you. So appreciate your representation, Mr. Gerlach. Any questions about the process? This recommendation from the state on all 3 cases, then the victim, then your statement, your defendant's statement, and then I'll sentence. Understand all that?
That's correct.
Does that work for you?
Yes, it works.
Okay, good enough. So Ms. Konepka, go ahead.
I just want to clarify, Your Honor, you want me to make a recommendation for Ms. Newcomb?
All 3.
Okay. I would like to first place on the record, Your Honor, I did not file a written sentencing memorandum as to Ms. Newcomb. However, I am making the same objection to the timing of the sentencing that I made in both Angela and Jacob Wagner's case, specifically, Your Honor, as this court knows, based on Gilbert Holding. The agreement at the time that these agreements were reached between the parties, there was also an agreement that the sentencing would be delayed until after the disposition or resolutions of all of the remaining co-defendants in the case. At Ms. Newcomb's time in 2019.
Very going to make a recommendation on sentencing.
I am, Your Honor, but
I got your objection. It's been in the record 5 times. I don't need to hear it again. It's overruled, so please make your recommendation.
the court is going to overrule me, but I need to make a record.
So, Mr. O'Brien, be ready to stand in, because there's no public debate today. The argument I'm hearing from your co-counsel has been beaten dead. It's been beaten dead. I asked her to make a sentencing recommendation. I asked her previously not to talk over me.
They're going to need
the next
gloves
thing
here
that
in a
happens
minute.
is she'll move to the back of the courtroom, and after that she'll be escorted out of the building, in which case you need to be ready to step in, because I'm not interested in old hash. She objected so many times, I have it in my sleep. I don't need it again. It's in the record. So I'm going to ask her again to make a sentencing recommendation on all 3 cases. If that doesn't work, then I'll take some disciplinary action. It's really easy to follow the rules until you don't have respect for the rules. So there's no debate today. We're just going to do this. I'd like you to be ready to step in case it doesn't work for her. Understand?
Yes, Your Honor. Only thing I would say for the record is that I'm not privy to the previous plea agreements on Jake and Angela and Newcomb, so I need some time to review those before I would if required.
I understand. Thank you. They're all in writing. Thanks.
And at least I think that Ms. Canepa should be ready to proceed.
I hope so.
Recommendations on all 3 cases.
That's what I asked for. Now, recommendations.
Judge needs a Snickers.
Regarding Ms. Newcomb, Your Honor, I'm deferring to the court on that. We did not have an agreed sentence in that case, and she has been very cooperative, and she did testify in George's case, and the case has been obviously pending for 5 years now, slightly more than 5 years now, slightly under 5 years, I guess, in sort of the. And so I would defer to the court as to what Ms. Newcomb's sentence should be. As to Ms. Wagner, Angela Wagner, I'll offer my objections after the court hearing so that I don't disturb the court any further on that. But I would simply ask the court to go along with the joint recommendation of 30 years. I know Mr. Craig has filed a sentencing memorandum in which he indicated that per a recent ruling, I believe December 9th, the court can only run 2 of the gun specifications consecutively. There are 6-year gun specs on multiple offenses, so of course the state would request that the court impose the 6-year gun specifications as the 2 counts. And then I don't really care how else the court gets to the 30 jointly recommended sentence. As to, I will note for the record that Ms. Wagner did appear and testify in her son's case, George Wagner's, in 2022. And the state believed, or believes still, that she testified truthfully in that case. So I would put that on the record as well. Regarding Edward Jacob Wagner.
They're just out of reach.
Similarly, Your Honor, would respectfully request, and I obviously did forward sentencing memorandums, that basically says the same things, but we would request that the court go along with the joint recommendation in this case, which is specifically, and I provided a chart to the court, just because I know at some point the court has to create a sentencing entry, and outlaying what the maximum sentence is in each of those. That was the joint recommendation, is that he receive maximum consecutive sentences. I think at the time that Judge Deering took the plea, obviously he also indicated he would be going along with the joint recommendations for what that's worth. And I believe during the colloquy with Mr. Wagner, he did ask him if he understood that he would probably, that he would not live outside of prison. And Mr. Wagner indicated that he understood that. The sentence that was jointly recommended is the same sentence that his brother, George Wagner, Wagner got, and then they are very similarly situated in that both of them went up on the hill that night and were responsible for the deaths of these 8 individuals, I should say, and on Fort Road. So again, Your Honor, I would respectfully request that the court impose the jointly recommended sentences. These were very carefully negotiated and constructed agreements. Both parties were fully represented, and these were the recommendations of all parties involved.
Thank you very much. So, Ms. Gall, how do you want to introduce your first victim? Initials?
Yes, Your Honor.
Okay, so who's first?
Andrea Shoemaker, she does not.
Okay, thank you, Ms. Shoemaker. Go ahead, thank you, Ms. Shoemaker. Just stand, if you would, right there is fine. The court reporter is the most important person here. She needs to hear what happened, so go ahead, thank you.
Bailiff's right in the way.
Andrea Shoemaker, Hannah Hazel Gilbert's mom. You three don't plan to carry out and murder my grandson, Ruger, who was 6 months old, laying in the bed between his mom and dad, Frankie, Roden, and Hazel Gilly, let alone your granddaughter's mother. How greedy of a grandmother are you? How greedy. You killed your granddaughter's mother. You're evil. You're evil. You are the spawn of Satan. And the Satan is Billy Wagner. You are the evilest mother to help plan, carry out, and take the lives of 3 other mothers. My daughter was only 20, and you want 30 years of your life behind bars? 30? She was 20! 20! She never even got to buy alcohol. She got 6 months of her life with her kid. 6 months. And Hannah Mae Roden, the love of your life, Jake Wagner, the love of your life, your daughter's mother, she got 4 days. Kylie Roden got 4 days. Do you know what kind of questions I have to answer? First, it was bad people came in. Next, they seen your faces on the news. So guess what? I had to explain more. Because they're not little kids no more. They're not 6 months old. They're not 4 days old. Ruger's soon to be 10. 10 years he's been without a daddy to teach him how to fish, to teach him how to hunt, to do all the man things. He has to depend on uncles, cousins. Because of you, Jake. Greedy Jake Wagner. You. I want you to suffer. This is what I want. And I've told all BCI. I want your mother to live and you boys to die as well as your dad. I want you to die so your mom feels the heartache of what it's like to bury a child. It's a heartache that never goes away. I hate you. You ruined my life. You ruined innocent children's lives. I hope you die. I pray every day you die. I pray your grandchildren and your children never want anything to do with you. And I hope they never do. I hope your daughter hates you with a passion and as much heart as I hate you, Jake Wagner. You shook my hand and acted as if you was my fucking friend. After you shot my daughter 5 times in the head. 5 times, man. Wagner, son laid between them. And Hannah Mae, she's holding her little girl. And you shot her. How cold and evil. You are a spawn of Satan. I'll say it again. Spawns of Satan. You and your brother. And you, evilness, created them. And Miss Rita, evil. Because you was the first to feel the guilt and say you were sorry, and it was your Christian duty to tell the truth. So I have not heard many words from you. My heart breaks for you to have such an evil, control, and response of Satan.
Thank you, Mr. Mecker. Who's next?
Actually, Your Honor, Ms. Canepa has 2 written statements that they requested she read, and then I do have one more live statement from Lisa Weisel.
Okay. Who's the first statement from Ms. Canepa?
It's Bobby Jolene, Your Honor, the individual who first discovered the victims in this case. This whole experience has been absolutely devastating. I just want to make it crystal clear that I hate you and I will never forgive you for what you've done. You're a coward. I hope the rest of your life is absolutely miserable. You don't deserve to be alive. It makes me sick that you're allowed to breathe the same air that I breathe. You have destroyed my life and the lives of so many others. There's a special place in hell for people like you. You want to act like you're a Christian, God's getting me in, and that cannot be further from the truth, for God hates people like you. You are the devil. All of this is because of you and your mother on a power trip, fueled by the need to control that poor child's life. And now your daughter has lost everyone. She no longer has her mother, heroism. You've taken everything from that child that you were supposed to protect and provide for. Your daughter will always remember you as a monster and a coward, nothing more, nothing less. All I really want to know is why. Why did they all have to die? Why did you think you had the right to take 8 lives? I'll never understand it all. It feels like a bad dream that I'll never wake from. Congratulations to you, Jake. You have made your daughter an orphan and put yourself in prison for the rest of your miserable existence.
That's the end of the first one.
That's the end of the first one, Your Honor. The next
And as you well know, the court reports ability to keep up with words, which is talk.
I knew you were limiting us on time, so.
Go ahead.
The next one is from Ruth Bergen, who is the stepmother of Gary Bergen. I would like you to know that you killed more than 8 people. Kenny, Gary's father, literally grieved himself to death over the murder of his son and the others in the family. Gary was a good-hearted person, and he would give you the shirt off his back. He never missed his father's birthday or mine. He made it to every holiday. I truly feel that you did much more, so much more these crimes than you're doing too. I ask for justice for Gary and the others in this family. Sorry.
Thank you very much. Last. What's your name, please?
I am Lisa Weisel. I am the niece of Chris and Kenneth and Nick. I am going to be speaking on behalf of the Roden family today. My family feels very strongly that some people have lost sight of what has brought us to this courthouse over and over again, year after year. Let me quickly remind you of the magnitude, the severity of this tragedy. This monstrous crime is the largest mass murder in Ohio. 8 people were brutally murdered. 2 young mothers and 1 young father. And I'm going to drop the baby's place I do. It is nearing the 9-year anniversary, and I assure you, no one wants justice more than our family. However, we do not agree with many hasty decisions to get it over with. We want all responsible parties to be shown no mercy, just like our family was shown no mercy. We can only pray that actions that take place in this courtroom today will not dismantle the justice that still has not been served. The Wagner family are master manipulators. It will tell of what the lies. The fifth are daring. They are a true danger to society, and this crime is nothing to be taken lightly or play jeopardy with. And on behalf of me
already been in the jail approximately 8 days, I'm not sure, on the records. And for a year, she wore the ankle bracelet and her movements and contacts were restricted. And she just recently had open heart surgery on which installed a new valve in her heart, and she's doing fairly well from that. She is on limited income. She gets $981 from Social Security, and we would offer to the court that perhaps the most appropriate thing would be a sentence that her service already be complete and there be no financial fine, because she really doesn't have the money to do that. Did you want to say something?
Thank you, Mr. Pierlot. Mr. Newcomb. Thank you very much.
And I'm sorry.
Stand up.
Please save her all the trouble. I'm sorry.
That's it. Okay. Go ahead, have a seat. And that would complete our presentation.
The noise is so bad in this.
So this offense is called obstructing official business. It's a second-degree misdemeanor. Maximum penalty is 90 days in jail and $750 fine. So that's the way the plea agreement was presented to the court. Those are the maximums defined by law. The other charges, whatever they were dismissed, so they're of no concern. With regard to the outcome, the probation department's been monitoring her behavior since 2018 and gives no negative reports. So that's a crystal ball in one respect, because the past often predicts the future, but it doesn't have to. So their recommendation informally, without a full report, is that she continue on supervision. So I'll set a 5-year term of adult probation supervision, 180 days jail, 173 suspended, 7 days credit. So no additional time now. You can, however, Ms. Newcomb, earn the additional 173 days if somehow you don't take this seriously and don't report or violate laws. So there's a long list of standard terms and conditions of supervision that the court's going to, wait, just go with I'm talking first and you don't. This is how the problems develop, all right? So you've been on supervision, but it doesn't count. The past doesn't count toward the future. That's pre-trial. The past does help me indicate I don't expect to see you again because the probation department seems to think you're not a problem. But I'm going to put you on supervision for 5 years and tell you that there's 173 days suspended in case you can't comply moving forward. I'm going to order the $750 fine plus the court costs, and then your ability to pay over time will affect whether it's actually collected. Because if I don't impose it today, I can't impose it later. Understand?
So if you don't
the terms
pay,
and conditions of probation
we'll waive
will
it.
primarily involve your compliance with the law, reporting requirements, and then any education or training programs they think are necessary for you to be a good citizen, which in your case may not be a lot, but that's generally the purposes of supervision, is to help people become law-abiding people if they aren't already. So 173 days at risk, there's a $750 fine plus the court costs that have to be paid, subject to ability to pay. Understand?
Can I ask you a question?
Sure.
Do I have to go to jail?
You want to answer that or should I?
I prefer you say, but I think no.
No, unless you act out.
Oh, okay.
173 days suspended.
Okay.
But it does demonstrate a good point. What I think I'm saying isn't what people are always hearing.
But there will be a fine. And
Yeah.
if I'm bad, I'll go to jail. But if I can stay good, I don't have to. But I do pay the fine.
Yeah, subject to your ability to pay.
Okay.
Like, the point's not to put you in poverty. point is to modify your behavior. If you have $30 left at the end of the month, then that should go toward the fine or the costs. At the end of the 5 years, if you can't pay it, you don't get incarcerated for being poor. It's forgiven at that point in time, but it is meant to be a punishment. Does that help you?
Yeah, I think I understand now.
Okay.
So
keep doing
there's
what
no
you have
incentive
been
to pay.
doing with regard to probation compliance.
But I still call in if I have to leave the state or something.
Or show up, whatever they say, you step and fetch it.
Okay.
Corrections or clarifications, Mr. Gerlach?
Clarification, in the entry it says 90 days is the maximum.
I did say that wrong. It's 90 is the maximum. Yeah.
And you said 170.
I did. It's 83, not 90 is the maximum. I said 180.
Yeah.
I bumped it up a letter, so 83. Thank you very much. My sentencing entry is actually back there on the desk right now, which doesn't help me here.
Send a clerk back there.
Thank you, Your Honor. So 97 credit, 83 suspended, $750 fine plus costs.
So if she violates probation, she serves 83 days.
Thank you for that correction. My apologies.
No problem.
Thank you. Ms. Canepa?
She was not directly involved in the murder.
Check out right now, if you would, Ms. Newcomb. That doesn't mean you have to leave the courtroom, just means I need that chair.
Oh, okay.
Thank you, Mr. Gerlach.
Thank you very much.
We'll switch to Angela's case next. And we'll need another chair. You can help us. I think we will. I don't have it.
This is crazy.
You have co-counsel with you today, Mr. Burns. Are you by yourself?
Mark Hunt is not here today.
Oh, my apologies. Okay. So this is State of Ohio versus Angela Wagner, case 156. Mr. Crapens is here on behalf of the defendant. Mr. Hunt's not appearing, so we don't need the extra chair. And you had an opportunity to hear the victim's statement and the state's recommendation, right, Mr. Ferentz? Crapens, I'm sorry.
You're fine. I have, Your Honor. Thank you.
Okay. And you heard it also, right, Mrs. Wagner? You heard everything that was said before, right? Okay. I want to circle back on one thing, Mr. Crapens. Was there any part of the plea hearing that you thought was in error or deficient or you wanted repeated?
No, at this time, nothing comes to mind.
Okay.
But
I wasn't here, but if there was an error, we can still fix it.
Appreciate that.
Did you note anything that should be emphasized, Ms. Canepa? Any problems with the plea?
No.
Okay, thanks. So it's the defendant's opportunity to make a statement, so Mr. Crapens gets to go first, then Ms. Wagner, you get a chance, so go right ahead.
Your Honor, thank you. First, with respect to maybe some merger issues, I suggested in my sentencing memorandum that there are two sets of 2 counts each that we believe should be merged for purposes of sentencing. That was counts 16 and 18, as I recall, and I think 20 and 21. If I can read my writing here. And I won't repeat the arguments therein. I pointed the bill of particulars with the specificity of what actually was charged, and it seems to me that they are similar headquarters that they should be merged. I don't know that. I have not read a response to that, so I don't know the state's position on that. With regard to the sentence or the plea agreement and maybe the agreement on sentencing, Ms. Wagner is very cognizant of the fact this court's not bound by anything that happened before this court took over this case. In fact, Judge Shearing also was not mandated to follow a jointly recommended sentence. Now, he did review it. He did say he would agree with it, but that in no way binds you. And my client is very aware that this court has the authority and the responsibility for deciding independently what the appropriate sentence is. So we do not walk in this morning expecting that this court will just rubber stamp the things that have happened before. But for the following reasons, I think that the court should accept the jointly recommended resolution in this case. As this court knows, these are horrible events. I appreciate the family being here and making the statements that they did. They have shown a lot of patience and I think and courage and repeatedly showing up for every hearing. I do appreciate that, and I know that their words do not fall on deaf ears. Your Honor, my client was involved with these actions. As far as her specific actions, she did not enter into any of these dwellings. She did not bring a gun personally. She did not pull a trigger. She did not directly cause the death of these folks. That said, she was aware of it. She took her own steps to try to assist in that plan. And that is something that she has taken responsibility for. In addition to taking responsibility, she has come into this courtroom and she's testified against her son. And that was a task that was not very easy for her. It was important for her to do so, but it was also very important for the state. The state knew that the remaining cases after Jake had entered his plea were still not 100% not an absolute win, because one person saying something sometimes without corroboration isn't enough to sway a jury to prove beyond reasonable doubt. It was very important for them to have Ms. Wagner come in and testify and corroborate the testimony, the evidence, and the facts that Jake had testified to. Toward that end, after Jake had proffered, we never let Angela review the statement, the proffer, because we wanted to keep a clean wall between the two of them, such that she was not parroting back what somebody else had said. And I think it proved her value to the state as a witness. And it's because of those efforts that the state entered into this agreement, which I know the state probably didn't like, but felt it was necessary, and I think that they probably made the right call. Ms. Wagner has lived up to her end. She will continue to live up to her end of the deal, which again doesn't bind this court. I do want the court to know that she has provided me this morning with a list and some certifications of completion of some programs that she's taken while she's been incarcerated for a very lengthy time in Delaware County. And I count offhand, I'm not going to read them all, but I count probably 40 to 50 different programs that she has completed. She has found something of a niche, and she's been in one place so long. She's been entrusted to act as a trustee, but also has taken it upon herself to mentor young women who come in to the jail, and then they come out, and they come back in, and she's told me many stories about the revolving door of women that she's met and been able to help. I believe that she, for the next more than almost 25 years of her life, will have a purpose. I know that she is the type of person who will listen, who will help to counsel, who will try to direct younger women into the right direction, a path that she hopes that they will take. She has done as much as she possibly do to improve herself, her situation, and to give back. She has written a statement at the appropriate time. I would ask the court to allow her to read that as well. All that to say, Your Honor, I believe that the jointly recommended sentence is appropriate. I know that in the plea agreement, we had agreed to a specific sentence for each of these counts. However, as my addendum to the sentencing memorandum indicated, I don't think that we can follow that because of how the Supreme Court has interpreted the law with regard to firearms investigations. I did include, it was yesterday at some point, a suggestion of how to arrive at the same, if the court is inclined to, and do so in compliance with what I believe would be the appropriate legal framework. Thank you.
Thank you. Ms. Canepa, do you agree that 18 merges into 16 and 19 merges into 20?
Talking about merging sentences together. So you're not serving two sentences for one crime.
Suggested by Mr. Craypence.
Yes, I would agree that there could be an argument as to 16 and 18, but not the 19 and 20, Your Honor.
Want to argue that further, Mr. Craypence?
No, so nothing past the motion. Thank you.
Okay, thanks. So I looked at the bill of particulars and read the indictment. I don't have all the discovery when I read through the trial transcript. I can agree that 19 merges into 20 and 16 merges into 18 merges into 16. So I presume you would have the court sentence on the higher level felonies, Ms. Canepa?
Yes, please.
So 16 is a felony 3 and 20 is a felony 4. So there'll be no sentences imposed on 18 and 19. They merge into 16 and 20. That being said, it's your turn, Ms. Wagner, for your statement.
You're here, so I have to tell me if I'm close. There I go?
Yeah. I've spent my whole life trying to be the opposite of everyone that I knew. Not too fluffy, not too worthless, not too strict, not too controlling, not divorced, not too ungrateful. The perfect daughter, wife, mother, grandmother, perfect person. Always striving for perfection, thinking that was what was wanted of me. All of this had been stuffed down so far that I didn't even know who that woman was. I didn't realize I was so weak and flawed and broken that it would lead me to make rash, emotional decisions. That when such a tragic event would happen within my family, I just froze. I couldn't think. I'm not saying this for justification, Your Honor. This is why it shames me to say at that point in time, I didn't consider the consequences those actions would cause, or the depth of pain that they would bring on the Rosens or others. I know the pain must be unbearable, because separated from my family, the ones I love most in the world, brings me unbearable, suffocating pain too. And for this, I am so truly sorry. I can't undo what's happened. But the regret and the remorse that I feel is my daily reminder of who I once was and who I do not ever want to be again. Thankfully today, I'm not that woman. I've committed myself to change, to growth, spiritually, mentally, emotionally, to letting God be my guidance. Each day I work on being a better me, rewiring my brokenness, living for a purpose so I can be filled with wisdom, knowing to slow down, to listen, and to ponder so I don't get carried away with any emotional decisions again. I'm not looking for perfection anymore. Now my desires and goals are for continuance of growth, for sharing the compassion and unconditional love to others that God shows me daily, and to remain this better me. God has opened my heart and my eyes. He has showed me what reality looks like. I've seen it in all the beautiful, unique women that I have met and been sharing housing units with. This world needs no more pain, so I give back any way I can, whether it is to show love, compassion, encouragement, a listening ear, a smile amidst their darkness, or just maybe by hearing my story. They will be enlightened of what real consequences made by emotional decisions looks like. My hopes and dreams are that I can make each day count for something good, to always move forward, not backward. Because all that I am today, I have to give that glory to God. It's His love, His mercy, and His grace that has changed me. Thank you.
Who's counting their piggy bank in the background?
Have a seat.
Your coins. Oh, those are the chains. Never mind.
So, Mr. Craypence, let me start with you. Thank you. I don't think the public understands the stress on the lawyers for both sides of the case. I also don't think the public appreciates the fact that without defense lawyers, there wouldn't be a prosecution. Because in our adversarial system, as much love as the state might get, the defense lawyers seem to get the opposite. Yet you step into those shoes And in this case, I've seen very capable lawyers working very difficult facts, often without any appreciation. So to the extent that you and Mr. Hunt did a fine job, you ought to at least be publicly acknowledged. So thank you very much for a long career.
Thank you, Your Honor.
The first part of the hearing, when the victims were speaking, was what I expected. A built-up, raw emotion of rancor and ill will, and all very understandable and unfortunate. If anything cathartic can come out of today, it might be of the fact that there's some closure, or maybe not forgiveness, not forgetting, but the fact that the process will have worked and people can move on. Whether you choose to accept that or not is yours, as any free person can, but maybe closure helps. There was a reference to this being the worst massacre in the state of Ohio. Well, let's go with something else. To call this the Pike County massacre, frankly, is condescending to the rest of the good people of Pike County. It's tragic, it's heinous, it's unexcusable, but it's not an indictment of the entire county. That's social media typecasting. The worst massacre in Ohio might very well be 1792 at Grenada-Hutton, when 96 Christian pacifists were killed by the Pennsylvania militia because they were Christian pacifists. But each generation has its own people who can prove the depths of depravity of human nature. And that's what this case did. It showed the boundless depravity of people who have no respect for others and their only self-interest in mind. And that's transgenerational. Since the dawn of man, this sort of depravity happens. So the raw emotion you communicated was expected is unfortunate, and I hope somehow you're able to get past it. Not forgetting, but getting above. But good luck, because what I just asked isn't easy, as you well know. With regard to sentencing, however, the court's not bound by nor has any role in using emotion. The government's responsibility is not to use ill will. We don't have people being burned at the stake as in the medieval days. We don't have public shaming. We don't have a remedy that works. We have analytical guidelines that courts are supposed to follow in imposing sentence. It's not meant to be emotionally driven. So I wipe all the emotion and follow the sentencing factors. The first set of factors are whether the case is more serious or less serious. Clearly, it's a more serious offense for all the reasons stated in the statute. Whether recidivism is likely is the second set of factors. Well, there's a long sentence coming. And I'm supposed to predict the future, which I can't do. So recidivism prediction is virtually impossible. It's backward looking. So I'm just going to find that the risk factors for recidivism are balanced equally against the less likely, because I don't know what you're going to be as a person or who you'll be after your long prison sentence, Ms. Wagner. The fact that you completed 40 or 50 programs might bode well for you, and it might not. So I'm not going to try to predict anything with regard to the future. You need to understand that there's a mutually recommended sentence. If I impose the mutually recommended sentence, then any opportunity you might have to appeal the sentence is waived or given up. Generally, when a person enters a plea of guilty, they give up any rights to appeal the verdict of guilt. So presumably you don't have appeal rights as to your plea. If I impose the sentence today as recommended, then there's no appeal rights on that issue. The only thing that might be left, dare I say it, would be ineffective assistance of counsel, and I don't have any opinion on that. So if I impose a mutually recommended sentence, your appeal rights are waived as to the sentence. Do you understand that?
Yes, Your Honor.
And that's what's going to happen. I lined up the numbers differently than the lawyers recommended, but they come up to the mutually recommended 30 years. So for purposes of the record, with regards to count number 9, complicity to aggravated murder, I impose a 9-year prison sentence. On counts 10, 11, 12, and 13, I impose a 9-year prison sentence. That's an aggravated burglary. For unlawful possession of dangerous ordnance, count 14, the maximum 12 months in prison. For counts 15 and 17, tampering with evidence, 3 years in prison. Count 16, tampering with evidence, 3 years in prison. No sentence on forgery, no sentence on unauthorized use because they merge. On unlawful interception of the oral communication, 18 months in prison. And then for the obstructing justice in count 21, 12 months in prison. And then engaging in a pattern of corrupt activity, 9 years in prison. Mr. Crapence is right to remind me of the recent case of Beatty. I saw that come rolling out first week of December. Maybe that was in my entry 2 weeks ago with regard to having to follow the mandates. A lot of people might think judges have unlimited reign, if you will, to impose sentence when in fact we have pages and pages and volumes of rules and case authority on how to impose a sentence. So the Beatty case tells me that there's a mandatory duty with regard to the firearm specifications to impose the maximum 6 years consecutively to each other. So there's a firearm silencer specification that has to be imposed on count 9 and count 22. So there's 6 years plus 6 years is 12. With regard to 9 more years for the aggravated burglary charges, those run concurrently with each other, consecutive to the firearm specification. So we're at 6 plus 6 plus 9. And then finally on the corrupt activity charge, count 22, there's a 9-year sentence, which is consecutive to the 9. So now it's 6 plus 6 plus 9 plus 9. Is my math right, Mr. Crapence? 30 years. The other charges all run concurrently, so that felonies 3 and 4 don't add additional time. It's 30 years in prison as mutually recommended. You're entitled to 2,244 days credit over 6 years. 6 years and 6 weeks. So that comes off your sentence as a matter of law, because past time has to count. With regard to economic sanctions, there's no fine. Your inability to pay makes that impossible, not only in the past but in the future. There's a legal obligation to pay court costs, processing, booking, pay to stay, medical expenses. So all those numbers should be added up and put on your bill. Your ability to pay depends on future economic circumstances, but it's a legal obligation to impose. When you're released, you have to be on supervision with the adult parole authority for at least 2 years up to 5 years. While on post-release control, you have to follow rules, regulations, restrictions on your freedom. If you fail to comply, you can be sent back to prison for up to 50% of the longest term, so that would be 50% of one of the 9s. So the 30 can turn into 34 and a half for additional violations after you're released at the end of 30 years. You have a legal obligation to register as a violent offender. There's a database. So at the time of your release, you have an obligation for at least 10 years to register as a violent offender. Tell the sheriff in the county where you reside where you live. If you fail to comply, that can be a parole violation, post-release control violation, or a separate felony 5 offense. And the legal duty can be extended if the state establishes just cause to extend it beyond the 10 years, which doesn't start running until you're released from prison. Did I overlook anything, Ms. Kneppa? Mr. Crapence?
No, Your Honor. My client has signed an affidavit of indigency from that code.
Thank you. Yes, I'll hand this back to you. You can have the filing done.
Thank you.
Further evidence specified there how thorough your lawyer is. See it? To the extent that I wasn't bound by the lawyers, I could have gone higher. I wasn't here when this started. The analysis is pretty true. The state needed you. And in fact, you came through with your part of the agreement. Does that matter? Well, morally, that's up to you. Legally, it's a big deal. In my journal entry, there's 2 cases cited that clearly explain the importance of cooperation, the benefits of mitigation. You help the state make the case. Jake helped the state make its case. That wisdom, wherever it came from, was the difference between a much worse outcome that might very well have been appropriate. I understand you didn't go to the 4 scenes. Nobody seems to talk about the fact that you're the only person who could have stopped the whole thing with one phone call. You're standing there with cell phones that people want you to ping to make it look like you're home. All you had to do was call in. Stop the whole thing. The depravity was that you didn't see the moral need to shut it all down. I don't need an explanation, but clearly any decent human being could have done that little bit to save so much. So with the fact that you accepted responsibility and cooperated, I was willing to follow the agreement. You'll see the Anderson case and the Rahab case is cited in the decision. They go back to 2017 case. The Supreme Court made it really clear twice in the same term the importance in the system of having people accept responsibility and cooperate. So for you, that's the only silver lining. That concludes that case. Ms. Wagner, they're going to walk out the side door and move you on. Thank you, Mr. Craigman. It's my pleasure to meet you. Thank you. My pleasure. Have a good day.
Didn't he come out of retirement to handle this case? I don't think he's doing another one, is he? Here comes Jake.
anytime you don't understand, do exactly what you did. Make it known.
Okay.
You can't miss this because of a hearing problem. Understand?
Yes, sir.
So thank you. Go ahead.
Thank you. We're going to do our best to make sure that he has full hearing and understanding, clarify anything that we may answer questions about. Your Honor, thank you for this time to speak on behalf of Mr. Wagner with regard to this sentence. I will keep my remarks relatively brief. I say relatively because the nature of this case calls for certain remarks to be made. But nevertheless, we have filed a sentencing memorandum on his behalf. This court is well aware of all the proceedings with this case, the joint recommendation of sentence, the plea agreement that had been entered into, as well as a defense agreement that was entered into, and Mr. Wagner has complied with up to this date and would continue to comply with. Again, my remarks will be brief, not because this is not a serious case. No one could, in their right mind, argue or anyone else that this case is not serious. And he spoke in terms of references to a master and that sort of thing. There are very few cases in the state of Ohio that would be of this severity. Certainly none that I have handled, although I have handled some multiple homicides involved. But out of respect for the family, parties, and all involved here, given that this has been litigated, it's been tried in one instance at least over the last 6 years, there's very little that I can say that someone hasn't already heard. What I would indicate to this court is that we did enter into, Mr. Wagner and prior counsel entered into an agreed plea agreement, a joint recommendation of sentence with the state of Ohio in this regard. That agreed joint recommendation of sentence was 8 consecutive sentences of life without parole for each of the aggravated murders involved herein. And it was also indicated that we could stipulate, agreed to waive and stipulate maximum consecutive sentences of both warranted, necessary, and appropriate in this case. I believe that probably would address the questions of merger. We know that Mr. Wagner knows that it's up to the court when it comes to sentencing. What I would indicate to the court is that he is fully aware that in entering the pleas that he did, he would be subject to a maximum possible sentence of 8 times life without parole, an additional 160 years if sentences were imposed to the maximum consecutive, and that 78 of the 160 additional years would be mandatory sentences. Again, the parties stipulated, or we stipulated, Mr. Wagner stipulated to the necessity that consecutive sentence, maximum consecutive sentences were warranted, necessary, and appropriate in this case in order to effect the agreement of the state of Ohio. Again, Mr. Wagner understood what his maximum sentence could be. He understands and understood then that it would be up to the court as to what his sentencing would be, but certainly he entered his plea knowingly, intelligently, and voluntarily, knowing that he was subject to the maximum sentences as already addressed of 8 times life without parole plus an additional 160 years. He also understands that with the joint recommendation of sentence, and he understood this at the time of entering his plea, that with the joint recommendation of sentence, he would not be able to appeal the sentence of the court if the joint recommendation of sentence wasn't imposed by the court. So I think he sits here before you fully knowing what those possible sentences are. He did at the time of entering his plea, and knowingly what the maximum would be. I believe I've addressed the issues of merger that the court wanted us to do, or asked the court, or asked us to provide additional information in that regards. Your Honor, I could stand here with myself and my colleagues in the Office of the Ohio Public Defender, having met with, and dealt with, and worked with Jay Wagner over the last 6+ years. There's many things that we could say. And I reference that my colleagues have what probably speaks to Jake Wagner more than anything is the extent and the value of his cooperation in this matter. He referenced it in the sentencing of his mother, Angela Wagner, that without his information, perhaps convictions would not have been obtained, pleas would not have been entered, and the state wouldn't be in a position where they are today. So again, I think that speaks to Mr. Jake Wagner as much as anything I can say on his behalf here today. Your Honor, I believe that at least by our calculations, we have 2,244 days of jail time credit. If that calculation is correct, I believe that was from a date of arrest of November 13th of 2018. I believe it's close to, it's not completely accurate, Your Honor. And I support taking notice of that. I think the last thing that I would offer is that Mr. Wagner has signed an affidavit in receipt. If I may approach. Yep, please. Has been notarized by himself, although with him a notary stamp.
You have a separate entry? You have a separate entry? Just sign them up.
Drive up to the board.
Your choice.
I don't have one with me.
I can do a margin note if you're satisfied with that.
Yeah, I'm satisfied with that, yes, Your Honor. Thank you.
That's all. That's it.
John, I would just conclude by saying that, again, we did make a jointly recommended sentence. Mr. Wagner understands what his duties and responsibilities and promises have been in the plea agreement, in the defense agreement. I believe that Mr. Wagner is a man of his word. Thank you.
Ms. Roberts, care to add anything?
No, thank you, Your Honor.
With regard to the merger, Ms. Neca, same argument, same discussion?
Yes, Your Honor.
Okay.
I suppose we'll reach the same conclusion.
Yeah, the same conclusion. So I think the merger is the same in this case as what Angela's. Academic as it might be, it's nonetheless essential to get it right. Your turn, Mr. Wagner. Anything you want to say?
Actually, Your Honor, I have a lot I want to say. But it's all right.
Just pull the mic closer if you would. Try to keep your voice projected.
You can hear me now?
Yes.
No, I have a lot I want to say. But if it's okay with you, instead of looking at you, I would like to look at the victims. They are who I really want to see.
You're entitled to do that.
You don't do that?
You can.
Oh, I can't?
You're entitled to do that.
Oh, I can. Okay.
Yeah. So whatever's comfortable. You can stand if you want. You can face them. You can face me. Just make sure no disrespect happens.
No disrespect, no.
Go ahead.
So, each and every one of you, well, not all of you, obviously, but I've had friendship or relationships with a lot of you, many of you. And I know full well that the weight of my crimes is what I've done to you and your family. There's no amount of apology I can give today, no amount of explanation, no thing I can do to help you with the pain you have, loss, anger, hate. Nothing can save that. But I'm not going to tell you, oh, this, and that. I'm going to tell you about me. Because, yeah, I used to be a manipulator. Ms. Gilly affirmed that, and I truly was. But after I committed this crime, I was still guilty. Ms. Gilly, I'm going to look at you because I feel you have the most hate. And this is for you. So whenever I committed those crimes, it was probably 2 or 3 weeks later, I was weighted down with the guilt I did. And I said the most sincere prayer that day I ever said to that day. And I asked God, didn't like what I did. Didn't like how I was living. Didn't like how the possibility my daughter or even my nephew would grow up to be. And I asked God, any means necessary. Any. And I can tell you today, I am not sorry I got caught. I'm sorry for what I've done. But I am glad I got caught. I 100% believe that it was Jesus who made me get caught to answer my prayer so he could become exactly who he's supposed to be to each of us. Lord, Savior. Because, Skilly, I don't show much emotion. It's not in me. A quiet hour tonight, just me and God, I do. I won't show much here. I'm kind of breaking up a little bit, but that's just me. I can tell you from my own experience, hate will not heal your heart. I'm not asking you to forgive me. I don't. But I ask you, if you are a woman of at least some kind of faith, you should really read the Bible, because hate won't do it. Hate won't condemn yourself. But I want you to know, what I want to tell all of you, is how I was, how I believed, how I truly thought I was going to die and go to heaven prior to being arrested. And how I learned in my own time, alone with Jesus, just him and his word. I set aside every human teaching I was ever taught, even John 3:16. I read the word for myself. John 3:16 don't save you. The Bible don't save you. Only a relationship with Jesus Christ will save you. And he did not promise one place in his word. I don't know how many of you have ever read the Bible. He's never promised he would save you from hell. He promised that he came here to save you from sin, to unleash you from the captivity of sin. We're all weak. We all fall short of the glory of God. I knew that, and I was one of those people who believed, okay, sure, I'm a sinner, I'll sin every day. It's not like, why should I try? Ask for forgiveness while I eat, go to sleep, and I'll be good. I wasn't good. That's not what Jesus preaches. Jesus says specifically, you come to me, all your burdens, all your sorrows, all your pain, and you surrender, and he will heal you. You know, some of you might know the verse that says you must become like a little child, or you by no means enter the kingdom of God. You must repent, or you by no means enter the kingdom of God. Repentance is what I thought prior to actually just sitting down and reading the Bible myself. It's not asking for forgiveness. That comes from repentance. Repentance is to choose to look at what you've done, hate it, and forsake it. Forsake sin. Nobody can say that they are a God-fearing Christian, born again, and think sin is nothing. At least little sins. Lying. Lying is just as much an abomination as any other thing. I've committed murder. I've committed every single sin that the Bible lists. Blasphemy, denying Christ, like Peter did. No, he never actually said it. But I have been in silence, and I heard someone else say it. It's just as much sin. Me? I'm going to tell you exactly how God changed me. And I know it's taking a little bit extra time, but I feel the judge will allow this. It took me about 2 months after I was arrested. And I read that Bible twice, cover to cover. And I did not like what I found. Not the fact that it doesn't give salvation. The fact that I realized I did not have it. I realized I did not have repentance and never did. Yeah, I believe it was superficial. My superficial faith had no power to change, no power to save, no power to have godly works in my life. Not one bit. But I was deceived, and every time I read it prior to that, I kept deceiving myself. Well, John 3:16, I'm good. No. You gotta read John through 14, 13, all the way to 21. He tells Nicodemus about repentance. He doesn't say the words, but he tells it. Men don't want to repent. Men don't want to repent if they don't want to come out of darkness. Because their deeds will be brought into light and be reproved. That's repentance. You know what we ask Jesus to do? Save us. Change us. Because we're sinners. He does not call us into a life of sin and just save us from hell. No, he calls us into a relationship so that he can transform our life. So we will be adequate ambassadors of Christ on earth in his love and his forgiveness. my nephew, the most two important and precious people in my life. And he's done that, I believe, so that I would know how he feels about all his lost children. And that's what I do. I don't need to tell you about how good I am or this and that or what the things that I do, because it's not important. I tell you this only because I care for each of you, each of your pain, each of your loss and your sorrow, because kind of like what they mentioned before, the judge mentioned, it's not about forgetting. Past is in the past. Strive for the future. But I can tell you this, I don't forget what I've done prior to my born-again moment. And I would describe it to you, but there's really no sense in doing it here. But whenever I was born again, I stopped forgetting. I didn't try to forget. I told my testimony to everybody I come across. I told it to them so that they may know that sin's not okay. Crying is not okay. It does hurt more than just us. It hurts everyone around us. Everyone we've known, people we don't even realize we're hurting. And there's a consequence to that. And I'm fully aware of my plea. I'm fully aware of the mercy that I've already received. And I am completely willing and ready to pay my consequence for my crimes here. But I want you to know that I have joy and peace and love in my life every day. It doesn't mean I don't suffer the loneliness or pain every now and then. It comes. And when it comes strongly. But I trust in God, because He gives me comfort every time it does. And what He does for me, He can do for you. And I'm not trying to make myself look big and think big shot on the news and all that stuff. Because I know everybody, not everybody. But many people are going to criticize what I say today. And don't get me wrong. Now you can see I did not write this down. Because for the past 3.5 years I have been thinking about what to say. How I can help you. Not just by myself, fixing or anything for myself, like where it is. But how I can help you. Each and every one of you. Even my daughter, wherever she may be. Everyone else who I've hurt. I want you to know the love and forgiveness that Christ has for you, so that He can bring good, as He promises, out of this terrible situation to help those who still have the opportunity to help. And I'm going to tell you one example of that.
Mr. Wagner, start wrapping it up, will you?
That's 3 minutes.
All right.
One thing, and I want to tell you, Sheriff, not all the details. If I came in contact with another inmate, this is after my plea. And he told me, because I told him, I'm confidential, I'm like, not necessarily how a Catholic priest does it, but what you confess to me, I'm not going to tell no one else. And he told me about he was going through a similar situation I was. How he was planning as soon as he got out, he was going to go kill his baby.
Stop.
Say what?
Wait. Wait.
Okay.
Go ahead. 2 minutes.
Well, I was able to spend time with him a lot. And I was able to share with him what my consequences and the pain I've caused to so many people. And I was able to lead him to making a choice for Jesus and not to commit to doing what he said he was going to do. And you know, there's so many people out there who have gone through so many things that you've gone through, sometimes even worse than what you've gone through. And I've read of so many testimonies how they have brought God glory through the evil that has happened, both on my side, the offender, and even on the offended side, showing His forgiveness. And I tell you, forgiveness is a powerful thing. Melts so much the hardest heart you'll ever see. And I do that every day with my testimony. My fellow inmates, my brothers. I love them. I shout out to them. And I don't care how much I get persecuted for being called a snitch, for being called everything under the sun. And it's odd because they don't criticize me for what I did, for the crime. They criticize me for taking a plea. They criticize me for standing up here and doing this, what I did for my brother. All of that.
Mr. Wagner, wrap it up, will you please?
My last sentence. I'm sorry. I just want you to know Jesus has a cost. Obedience, repentance, and total commitment. And when you do that, as I've done, if you've all done it, I don't know, you will transform your life. I hope you all have been touched by that and at least somewhat planted a seed to your hearts and be healed, at least somewhat. And I do pray for you all. That's all I got to say.
Have a seat. Thank you, Mr. Wagner.
Nothing further than the defense. Thank you very much.
So, Mr. Wagner, that allocution, that statement, further demonstrates the role the court does not serve. Everything you just said is perfectly appropriate. It's been heard many times before, as has the victim. But to the extent that there's a religious overtone, I don't factor in religious values. It's the same standard. The legal prescriptions, the laws of the government that I impose. I heard remorse. I heard your understanding and your explanation for it. But to the extent that you might, or somebody might have taken that as preaching, that's fine, except it has no meaning to me, except for remorse. I know it's more than that, Mr. McVeigh helped me understand, but it just demonstrates that the same ill will and rancor that came from the victims, understandably, is now your faith experience on your side, neither of which is the role of the judge, the duty of the law. So it highlights what goes on in courtrooms on a regular basis.
Your Honor, what I might add to that, perhaps by way of further explanation, is that I believe from my conversations with my colleagues with Mr. Wagner, that the statement that he made there was, he wanted to speak to the victim's family, and rightfully so. But I don't believe it was in any way intended to sway the opinion of this court when it comes to sentencing.
We said the same thing different ways.
We did.
I can't accept that.
We did.
For benefit of the record, a lot of the victims in the gallery walked out along the way as they're allowed to. So they don't have to hear what he chooses to say. It's how it works.
Yes, Your Honor.
I think this day is more intense than many, but it's all too familiar on the criminal court documents.
Yes, Your Honor.
With regard to sentencing, Mr. Wagner, the court has the same analysis. Severity factors, well, obviously, clearly, there's more serious factors. There are no less serious factors. With regard to whether you're likely to be a repeat offender or not, I'm not going to have a crystal ball to project where you are after a long prison sentence. So I'll just find that the recidivism factors balance out. It's unpredictable, but I did the analysis and thought about it. With regard to the penalties imposed, count 1, aggravated murder, life in prison. Count 2, aggravated murder, life in prison. Count 3, aggravated murder, life in prison. Count 4, aggravated murder, life in prison. 5, aggravated murder, life in prison. Count 6, aggravated murder, life in prison. Count 7, aggravated murder, life in prison. Count 8, aggravated murder, life in prison. Count 9, conspiracy to commit aggravated murder, maximum 11 years out of Department of Rehabilitation and Corrections. Counts 10, 11, 12, 13, aggravated burglary, maximum terms of 11 years in prison. Count 14, possession of a dangerous ordinance, 3 years in prison. Counts 15 and 17, tampering with evidence, 3 years in prison. Counts 16 is tampering with evidence, 3 years in prison. Count 18 merges, so there's no sentence on 18. Count 19 merges, so there's no sentence on 19. Count 20, unlawful interception, 18 months in prison. Count 21, obstructing justice, 12 months in prison. Count 22, engaging in a pattern of corrupt activity, the maximum 11 years in prison. And then count 23, unlawful sexual conduct with a minor, a 4th degree felony because of more than 4 years of age difference. In that case, 18 months in prison, the maximum sentence. With regard to firearm specifications, the court's duty-bound under the recent Beatty case to impose mandatory 6 years on the first firearm spec taken from count 1 and 6 years on the firearm specification found in count 2. You're entitled to 2,244 days of jail time credit up through including today. You're required to register as a violent offender. You also have sex offender registration requirements. The sex offender registration requirements apply upon any release from prison, which would be for a period of 25 years, registering at least every 6 months with the sheriff in the county where you reside. If you change your address, take into employment, then you have to change your registration anytime you change your variable. The violent offender database, as you heard earlier, is a 10-year registration, which can be extended. And if you fail to comply with the sex offender registration or the violent offender registration, that can be a violation of any terms of release or a separate felony at the time. The Chief Justice appoints retired assigned judges to work on cases where there's conflicts or problems. And I take that very seriously. It's a privilege after retirement to be granted the opportunity to come back and continue to help my colleagues. That's why I get out of bed every day. There's a need, there's a problem, maybe a skill to apply to resolve the need and the problem. That's how I got here. We talked about this with her dad months ago. I got 2 problems when I walked into this case. I'm going to explain the 2 problems. The first problem was a recommendation on your case that was the same as it was on your brother's, life without parole, which is what he got, right? How did he get there? He went to trial. He had 10 weeks of trial, and he had thousands of dollars and dozens of witnesses and emotional energy and staff energy, people energy, resources energy to get him to his conviction. Yet the recommendation here is the same, giving you no credit for all the cooperation that you gave. As Mr. McKenna said, if you don't have corroboration of a cooperative witness, you may not have any case. So I have to resolve the first problem is how is it that I'm supposed to treat you the same when in fact you didn't act the same. That's the first problem. The second problem is how do I resolve the good deal that your mom got? 30 years is a really long time. That's a really good deal for the level of the conduct, especially since she could have stopped the whole thing dead in its tracks before it ever happened. And I don't let her off the hook because she didn't go to the scene. I put her equally responsible because the eyes of the law put her equally responsible. So my second problem is how do I resolve what looks to me like some sort of gender violence? And here's how I resolve it. I give you the opportunity of parole after 20 years on your prison sentence. So you do 6 on the gun spec, you do 6 on the gun spec, you do life on all the other counts, everything concurrent, with the opportunity of parole at 20 years. So 32 years out, you get your chance. Because you cooperated, because you did something to acknowledge the responsibility for the crime. That's not appeal, but that's as close as I can come to solving the problem that's handed to me by these ancient plea agreements. If everybody wants the last judge's sentencing deal, they should have sentenced him under the last judge. Everybody knew Judge Deering was gone right after the last trial, but nobody rushed it in to get it. And when I show up, I solve the problems the way I'm supposed to. So you get your chance to talk to the parole board 32 years from now. And then they do their job, whatever it might be. So I'm not going to sign off on a deal where you get the same for cooperating as your brother does for going to trial. There's the explanation. Court costs, processing, booking, pay to state medical expenses, have to pay as a legal obligation. There's no victim restitution because they have civil remedies available. go ahead and be excused. We're going to register you under both those registries, and we're going to take a break. So we're going to go off the record. Thank you to the lawyers.
I don't believe what I just heard. You slaughter a family in their sleep. 8 of them. Hang on, I've got to find out where my plug is.
Call from. To accept, press 1. To send a voicemail.
Call back and tell me your name. I need to know who it is first before I pick it up. He got 8. He's still stunned. Jake's still sitting there stunned. This is so much better a deal than defense wanted, and the judge did it because he doesn't like the prosecution. We've got family members. Let's try this again.
Call from. To accept, press 1.
No, you need to call back and say your name in the prompt. I need to know who it is before I pick it up. The judge did this to spite the DA, who he got snarky with right before the sentencing. Third time's the charm. Otherwise, I block the number.
Call from. Allie B. from.
Allie, I knew you could figure it out. Thank you. Welcome, Allie. How you doing?
Hey, I said my name like 3 times, but anyway.
Okay.
I just wanted to say I'm so angry because how can you get concurrent for killing 8 people
and
parole after 25 or 30 years? It makes no sense.
No. First of all, the judge doing the sentencing the way he did, the time where he's doing this, there are deals on the table where the part that the person who is getting sentenced has to carry out has not happened yet. They have to testify in a case that has not started yet. They have to be fully cooperative. That's part of the deal. Okay, not
right.
And the judge instead says, I'm going to sentence them now before they do their part of the deal.
Unbelievable.
And
I'm speechless.
We had testimony here, or we heard today that these are master manipulators. And they get up there, and the judge bought it hook, line, and sinker. The whole thing. He says, "Yeah, that doesn't have any effect on me. Yeah, you gave a sweetheart deal to somebody who helped eliminate and through the eyes of the law is guilty of killing 8 people, planning and murdering them in their sleep."
Right, and he's like, your mom. He was so mad at her, and her sentence went long enough
because she could have made a phone call and stopped it. Anyone could have made that phone call.
Jake could have not pulled the trigger, too.
That is unbelievable.
So, I don't know. It's terrible. We'll see what happens with Billy now.
Yeah, we're behind on this one. There's a hearing going on right now. It might be over by now in Billy's trial, which is upcoming.
All right.
But
I'll let you go. I just
Allie,
had to.
thank you.
I had to vent. Okay.
Man,
bye.
Crazy. We'll see you. Bye. That was. This judge has no fear because he does not have a position. He can't be voted out. He was literally called back out of retirement. Similar to how they get appointed. It's not the will of the people saying, yeah, we want this judge to serve. He gets called back, has a beef with the DA, and whatever happened before him, doesn't like it. And he takes it out, and the only way he can, and that is, well, first verbally berating them a little bit, chiding her in open court, and then giving sweetheart deals, almost mocking, in a way, the victims in court while they're there to give victim statements. Cuts them off, gives all the victims a combined 10 minutes. and then lets Jake give his whole sermon. Now, about the sermon, let me just say, I do believe people can change. I do believe people who find a religion that teaches good morals and agree to live by it improve their lives. That's great. He is not and may never be in the place where he should be preaching to anyone, especially at his sentencing. No. Wow. That was crazy. So Jake watched Sarah Boone and Melody Ferris, and he said, "Here, hold my jail hooch. Watch this." Wow. And that judge, that wasn't right. I'll say that wasn't right. My one hand is covered with Dorito flavoring because I was told to get some popcorn for that. I ate popcorn throughout the entire thing. I'm stuffed, by the way. I got some Smart Food because I guess it's healthy, right? Smart Food popcorn, which is healthy, but it comes in nacho cheese Dorito flavor, which I think is not healthy. So I'm not sure what the balance is, but I'm pretty sure I had more than a cup full, and that was supposed to be 70 calories. So this is part of my diet. That food's part of my diet, just for the record. That was crazy. Rub it in. Sorry, I got those at the store. I got them at Sam's Club. I didn't know they were like a rare item. It was funny. My wife and I were at Sam's Club. We were shopping. I need a napkin here, just one second. We have a roll of paper towels just for this very reason. All right. We were at Sam's Club and we were just talking, and it seems like every brand has done what Smart Food and Doritos just did, where they go and they do a collaboration. They're like, hey, Reese's Buttercups, peanut butter cups are good. Why don't we collaborate with animal crackers and we'll make Reese's animal crackers? And every single brand out there has like this, hey, we're going to do our thing. We're now going to do Cheetos, but they're going to be spicy, fiery, hot with lemon. And it was weird. And we saw this. I thought, I have to try those. I skipped the dill pickles. Can you cover the dad's trial that's coming up soon? Here's the problem. The reason why we didn't cover this court case, we did jump to it a couple times when it was happening. We didn't cover it because the audio is terrible, as you guys heard. It is awful. The video during trial is worse. The judge most of the witnesses were not visible. We were just staring at the seal and hearing voices and trying to decide who was talking. It was no good. Amber C, member for 15 months. Thank you so much for the covering. It's been hard to find coverage for seniors hearings. Yeah. This one, the judge even attacked law and crime for the title of the case they used, calling it the Pike County Massacre, saying that's not fair for Pike County. Well, it happened in Pike County and it's a massacre. Would you rather just call it Tennessee or what? That one place? Oh man, I want Reese's Oreo. That audio was terrible. I did everything I could to take the bottom and the top end off, but there was just so much noise. And the microphone, the cameraman was using court audio for the judge and for Jake a little bit, but the adjustments for the mics, you could hear were on the camera. So anytime he's making an adjustment, you hear this when he's handling the camera. And so we got that noise and the camera moving around, as well as the bailiff kept standing in front of it. It was just a bad deal all around. Oh, sorry, Ohio. I said Tennessee. It's Ohio. I was thinking Allie B from Tennessee. That's where I put it there. Ohio. Man, that's wild. That is just absolutely wild. So a couple things on my mind now. I'm still thinking about the most delicious Smart Food popcorn I've ever eaten, which is Doritos flavor. Yes. Don't call 911 for cats and trees. Can they refuse to testify now? What is the incentive to have them testify? They've already been sentenced. You can't go back and re-sentence them and like, wait, I changed my mind. It's done. They're like, what if we don't want to testify against Dad? Nope, sorry. They might still do it, but Rage Crochet, it's tricky. I wish it were that simple to just go in and fix it, but a lot of the court systems have integrated software and hardware, like those mics, those flat, they're called boundary mics that they use on the table that the lawyer was holding up in front of Jake, which is not a good way for that mic to be used. They're tied into a computer system that uses the recorders and things. It's not just straight audio, so it's tricky. But are we going to watch Billy's motion hearing? No, my head can't handle that anymore. It can't. My daughter is trying to show me some other chips, some other popcorn that we bought, which is this one right here. Strawberry champagne flavored drizzled kettle corn. I made Mrs. Ari get that one, but I don't like it. All right. Samantha Terry, thank you. I'm showing we're at 5 hours, just pushing 5 hours right now. So we're gonna wrap things up for the day, I think. Iris member for 12 months. Congratulations. You got that orange courthouse. It looks great. Just realized I got my orange courthouse 1 year with you and your family and these amazing people. Love y'all. Mel Poi, almost to the year mark, 11 months, says, snowed in, I need popcorn. I would tell you, you can find it on Amazon, but it's ridiculously expensive. I don't know what I paid for this at Sam's Club, but I'd be surprised if that bag of popcorn was more than about $4 or $5. Sam's Club, it's like $27. It's not worth it. Or no, online it's like $27 on Amazon. Sam's Club was cheap. But of course you have to be able to find it. They bring that up during Billy's prelim today. It's a condition of the death penalty. I just can't put myself through that terrible audio one more time. Judge is crazy. You have to show everyone the shopping list I made for us on Canva. I think I've got that pulled up. 1 second. You just barely sent me that. Okay, let me download it really quickly. Download. Compress. Pantuflet's Murder Aisle Shopping List. That's what this is. Okay. So just 1 second. We'll get this pulled up. Okay, we're going to put it behind me right here. And then I'm going to turn off this, and I'm going to disappear as well so we can read it together. Pantuflet's Murder Aisle Shopping List. We've got shells, buckets, lighter fluid, rope, saw, burner foam, sponges, snacks. I like the snacks. Duct tape, hydrogen peroxide, paper towels, garbage bags, suitcase or gym bag, bleach, more snacks, and then gloves, shovel, matches, candies, zip ties, tarps, and once again, more snacks. Looks great. That is, oops. That's weird. I have to do it like that. That's a pretty good list. That's a pretty good list. Oh, grabbed the wrong one. We suddenly went holidays. We'll go back in court. There we go. Yeah, surprise, I'm not actually in court. I know that just disappointed a lot of you, but that's here we are. I am stopping for the day. Yes, if you want, I know Law and Crime is still airing the Wagner hearing, and that's out there if you can, if you enjoy that. Lizzie Dog, if judge has beef with the prosecutor, isn't that a conflict? Yes. Misconduct. Justice for victims has nothing to do with personal beef. Not fair for the real victims. Yeah, I would agree that there is definitely a conflict there. He should recuse himself. Mary Murphy tried it, didn't like it. The docket's covering this right now. We might, let's see if we can portal over to somebody who's still covering it. If you guys would like to continue that case, I can do that. Let's see. Okay, we'll portal over to the docket. And that one's done. They're covering it right now. So I'm still stunned. I'm going to just think this one over a little bit. It is Friday. We are expecting to have, first of all, we want to cover that Tennessee case when it starts. We'll probably try to find some smaller court cases that happen between now and then, because that's like 2 weeks out. But cases are starting. We're going to pick them up. We might have to do some, you might watch 2 at once. You never know. Trying to catch up on everything. But that being said, I just put myself in the wrong corner. All right, there we go. Happy New Year to everybody. Happy weekend. Hope you have a good one. I'm going to work on the bathroom again with my new tool, my hacksaw. Hacksaw, I think is what it's called. Last time we watched 2 at once, you were featured in one of them. Drama Llama. We'll try to skip that. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. Please stay safe till we go live again Monday morning. Have a great weekend, everybody. Yeah, Red Pen's like, phew, never so glad to have a stream in. Thanks for putting that list together, Red Pen. I appreciate that. Now you can go shopping for everything you need. Oh, we've got a prank call. Hang on. Hello?
Hello? Yes, hello. Are you the owner of 5197 South, 1150 West in Utah?
Mm-hmm.
We're actually buying houses in the area. Are you interested in selling?
I am.
I see. This property, is it your residence? Is it vacant or currently being rented?
It's mine, but I'm not in it right now.
Oh, you're not planning to sell it yet?
Well, I'm not in it. I own it, but I don't live in it right now.
Oh, I see.
It needs a couple of repairs.
Oh, no worries. We buy houses as if. You said you're not in it. Is some relative staying there or currently vacant?
Nope, no relatives. There's a guy, but he's not a relative.
Oh, okay. There's a guy who's living at the property?
Yeah, I've tried to get him to leave, and he's not interested.
Oh, I see. But you are the owner of the property.
Yeah, I guess they call him like a squatter. Is that what it is when somebody just like moves in?
Oh.
Yeah. Do you know? Do you have any advice? I mean, I've offered him like food. I've offered him a little bit of money, but he's still he's in the basement. He creeps me out every time I go in there.
Oh, wow, that's kind of creepy.
Yeah.
You already called the police and stuff like that?
No, he runs. Because there's the hole in the wall. We had to do, because of the meth, we had to do some renovations on the back. So there's a big hole in the back of the house, and he'll get out the back when the police show up at the front.
Mm-hmm. Oh, I see. So you kind of, it's kind of some kind of creepy. Yeah. And you don't know that guy is?
I just call him the guy because, he has no interest in forming a relationship. And honestly, he's not my type, if you know.
Mm-hmm. Oh, I see. I got that one. And but you are planning to sell it, if ever?
Yeah, but I talked to a realtor. They said I have to tell people that there's a squatter in it, and that's sort of like I haven't had a lot of people walk through after they find out there's a guy that he jumps out and scares them, and then he runs off.
I see. So they are not interested to buy it anymore?
Well, I'd love to sell it, but a lot of people don't want to buy a house with a squatter. So if you guys have any ideas, or I don't know, just like a squatter removal kit or something you can get.
I'll go ahead and talk to the buyer if there's any advice that he could do. But may I know who am I speaking with?
Dwayne.
Dwayne?
Yeah.
And you're Dwayne?
Yeah, Dwayne, like The Rock.
Okay. And your last name is?
Bourne. Like Jason Bourne. Like Bourne Identity. Like that.
I see.
So think The Rock and Jason Bourne, and that's me. I'm like halfway between. I sort of look like both of them a little bit.
Sure. I'll go ahead and note that one. But this property, you said it needs repair, right?
The hole definitely needs to. We used, you know what a skid steer is? there was one room where they had the meth lab where we had to just like take everything out, and we used a skid steer to sort of like drag it out through the back of the house, and we haven't closed that up yet. So it probably just needs. I'm thinking just like plywood and some siding would probably do it.
Okay, got that one. But did you make any updates for the last 3 to 5 years?
Yeah, we had the address painted out on the curb, like really nice, and the fancy one with an American flag. I did some trimming of the trees a little bit. I tried to make it like into some letters, the alphabet. It didn't work out really well, but we've done stuff to it.
I see. But what's the condition of the roof or the kitchen?
There is no roof right now.
Oh, I see.
Yeah, we like to think it's like open to the sky. So it's like you're living in a house, but really you're out in nature.
I see. Got that one. And let's say if do you already have a price in mind? How much you will sell it?
I don't. I know it's probably going to be, with the way prices have been going, a lot more than I paid for it. And we've owned it for 12 years now. So
I see.
I don't know. Other things in the neighborhood used to be going for a lot until we had the roof problem, and now the neighborhood it's gotten cheaper for some reason. I don't know why, but I'm thinking about 300 or so.
I see. Got that one. And yeah, we're actually buying houses, and as this, let's say there's no more squatter in it. How soon would you be willing to sell it?
Oh, like today.
As soon as possible. You said you spoke to a realtor, but did you sign a contract or not yet?
No. I talked to a guy who sort of does realty on the side, and he says he's a realtor, but he doesn't have his license. He just sort of like does it. So there was no contract. It was like unofficial.
Oh, I see. Got that one. Well, aside from me asking, what made you decide of selling it?
The squatter nearly gave me a heart attack, and I'm like, look, I can't put up with this anymore. I just have to. Now I almost like have PTSD when I go in there, even when he's not there. I'm just expecting him to jump out. It's just creepy, so I can't do that. I
see. So that squatter, whenever you call police, he would run away, but then he would keep on coming back. Is that right?
He comes back. He lives in the basement because the basement, obviously, there's a roof over the basement because it's the floor of the upstairs. And he doesn't like the fact that there's no roof upstairs. He actually was swearing at me about that, saying I need to fix it. But he's not paying me anything, so I'm not going to fix it for him.
I see. Got that one. And yeah. Do you have an email address, if ever?
It's called, it's to be deleted at yahoo.com.
Number TOBE,
and then the word deleted
at
yahoo.com.
Okay. I'll go ahead and forward this to our buyer. Would you be available for a call tomorrow?
I don't work on weekends. I like to divide my work days and my play days, and Saturday is my play day. So
I see. How about on Monday?
Monday, probably after 9 a.m. might be interested.
Okay, sure. That would be 10 in the morning then.
Okay.
Okay. And yeah, by any chance, how many bedrooms and bathrooms are there?
Oh man. Okay. You come in the front room and it's sort of split level. So you come in and you go up on the left is the family room, and then there's a little opening. We made the opening that goes from there into the kitchen. Then over on the right with the hall, there's a bathroom on the left as you're walking down the hall, and then we have the one bedroom in the back on top, and then the one on the right. So 2 upstairs. If you were to go downstairs on the right, on the back corner, that's where the meth lab one was. So that's sort of, we opened the door where the closet was, so I'm not sure if we can count that, if we took out the closet with the skid steer, but that should be a bedroom. You can probably rebuild the closet, it would count. And then one across the hall from that, so I guess you'd say 4. Or 3.5 if you don't have the closet.
I see. Let me go ahead and check that. Is this under HOA?
Is it under? No, I don't.
No HOA.
No HOAs.
Okay. Thank you. And how many car garage are there?
No garage.
No garage.
It had one. I had a barbecue, and we were cooking under it, and I had left a lot of the burgers on with the top down, and it got really hot, and I opened it to try to see if they were done, and the flames just went right up the top. It burned most of it, so we just used a hacksaw and cut off the garage, and so it's sort of like, it looks pretty good. It looks like it was like built that way, but no garage anymore. It's just like a black cement over there now.
Okay, no worries. Well, if you don't mind, how long is that squatter been staying at the property?
What, 7 months now?
Oh, for 7 months. I see. He just doesn't want to leave there. But he's not a crazy person.
He looks crazy because he doesn't shave. So he's got like a huge beard. Think of like Santa Claus on speed is sort of like how he looks like, just crazy. But he's not, I don't think really he's crazy. He just like pretends to be.
Oh, I see. I understand. But thank you so much, Train. I'll go ahead and forward this and we'll call you back on Monday, 10 a.m.
Awesome.
Okay?
I look forward to it. See ya.
Okay, thank you. Bye-bye.
So as we're wrapping up for the day, you guys have to be here on Monday because around 9 or 10 o'clock, we're going to get an epic phone call from a buyer. So, I don't know why they call me about a property in Utah that I do not own, that I've never owned. Ever. Oh, man. She bought the email address and everything to be deleted. Oh, man. I love it. All right. Tonight, when you go home, please hug people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again Monday. We're done for the day. I'm all done. You guys have a good one. Have a great weekend. Bye-bye.